Well, the order of that council court has already been complied, my lord.
Order has been complied with.
Yes, my lord. It is complied.
But some action should be taken against you.
No, my lord. In the open court, my lord. My lord,
We will not leave the matter like this.
I'm sorry, my lord, but in the open court.
No question of sorry.
In the open court,
You will have to face consequences.
my lord, in the open court, he is
This is not
directed,
done.
my lord. My lord,
We cannot tolerate this.
no, in the open court, he is
In no
directed, my
case.
lord. Everyone in the court, my lord, they have heard it, my lord. Then after I move before this honorable court, my lord. But in that part, last part, my lord, where it is that for the
We can never tolerate this.
no, well, I'm sorry,
All
my
right.
lord, but
All right, you go before the learned single judge.
no, I'm sorry,
No question of sorry, you will have to go.
no, my lord, in the open court,
You
my
will-
lord, is directed, my lord. In the open, then after I move.
Mr. Counsel, we will initiate contempt proceeding against you right now. And we can send you to jail. Your conduct is such. You don't know how disturbed are we.
My lord, I am equally pained. And let me tell you, lordships, after that, when I went down, I was told about the order. And I told your lordship may see, my lord, the order has been complied by the government. I said, don't wait, because she is president of that managing committee. So we complied it the very next day. If your lordship will see the order, my lord, the compliance is not by the society, it's by the government.
Go before the learned single judge. So was the order passed by learned single judge. This intra-court appeal was not listed on 29/4/2024 and was specially notified on a mention having been made, on urgent mention having been made by Mr. Ashish Kumar Misra, learned counsel for the appellant, that in a contempt proceeding, that is CONTC number 2590 of 2024, an order had been passed by the learned single judge, of this court, directing the superintendent of police Devgarh for production of the additional district magistrate Devgarh for disobedience of this court's order dated 31/2024, which is under challenge in the present intra-court appeal. Full stop. The order dated 29/4, in view of the submission so advanced, this court had passed the following order on 29/4/2024. Full stop. As the said CONTC number 2590 of 2024 was to be listed on 34/2024. The same was listed and before the learned single judge. Full stop. Learned single judge has passed the following order on 34/2024. Full stop. Full stop. The observations made by learned single judge in the order dated 34/2024 are quite disturbing to the extent it relates to the conduct of learned counsel representing the appellant. Full stop. Learned single judge has specifically recorded in the said order dated 34/2024 that any writ appeal was filed against the order, violation of which was being alleged in the contempt application. Full stop. Next. Be that as it may, comma, it has been pointed out by learned counsel for the appellant that this court's order dated 31/2024 passed in WPC number 25677 of 2020 has since been complied with. Full stop. List this appeal in usual course. Full stop. The CONTC number 2590 of 2024 has been directed to be posted on (13/5/2024). Full stop. The said matter shall be listed before the learned single judge on 13/5/2024 within first 5 cases.
May it please your lordship. My lord, your lordship may kindly permit me to place the order dated 22/4/2024. The qualification regarding junior fishery technical assistant, my lord, since that notification is not tenable in the eye of law, so only your lordship is of formal nature. I have filed an IA for a small amendment, that notification has to go, because the rule has to go, I have made a prayer. So consequential, that notification is made now. So prayer only, that I have also prepared, the consolidated petition, along with that, I have also prepared, my lord. So very small prayer in that, that last line of the prayer in the read petition, I may be permitted to add that the notification dated 33/2024, so far JFTA is concerned, that may be passed in IA number 6123/2024.
Yeah, this can be allowed.
That flag S,
Hmm?
flag S, my lord.
Yes.
My lord.
We can allow. IA number 6123 of 2024. This application has been filed seeking amendment in the writ petition for challenging so it's writ petition for challenging an advertisement. Challenging advertisement number 1465/OSSC dated 33/2024, issued by Odisha Staff Selection Commission, bracketed opposite party number 3, relating to appointment for the post of Junior Fisheries Technical Assistant, bracketed JFTA. Okay. We are of the view that the relief which the petitioner is the relief which the petitioner intends to seek by way of amendment is integrally connected with the main prayer in the writ petition. Stop. IA number on this application is accordingly allowed. Stop. Yes. What do you want?
I'm file, your lordship, if permits, I'll file the consolidated petition, my lord.
Second consolidated.
Second consolidated, yes, your lordship.
Consolidated petition is there. So he will file
Second.
My lord.
second consolidated petition incorporating all.
So every time. What is
Your
this
lordship
system?
will
I don't know.
permit,
the
I'll
system.
file it, my lord.
It is in the admission statement. First of all, absolutely some- One
Affidavit.
My lord, that is.
No, you have
Every
not
time
yet
we will have to
filed
file
the
counter
counter.
affidavit.
So this matter has not yet been admitted.
My
So it
lord,
would have been better if you withdraw and file fresh,
no,
so that comprehensive counter affidavit can be filed by them.
in this
Because
case,
you have filed many affidavits already.
my lord,
So so it must be some comprehensive petition,
my lord, in
so
this,
that it is better for him to, it would be easier for him to reply.
my lord, in,
When last month was hearing this matter, there was a proposed amendment. That actually we filed an affidavit that yes, these students are meritorious and should be more suitable. Now, government doesn't accept it. Government says, no, the rule is there.
All right, we are here to decide that. That is a different thing.
So, that is short matter.
Anyway, if
Challenging the virus of the rule. That, My humble submission is nothing
All
much
right.
more to add.
Yes, sir.
All right. Well done.
Only consequential, because if the rule goes, then
All
definitely
Then you
If your
file
lordship will-
counter affidavit to the
counter has been
second
filed.
consolidated petition which
No,
he wishes to file.
count.
Counter has been filed and a rejoinder has been filed.
The file count, yes, file adjournment. Only because of my lord's fact query last time, I had. filed
That
the
affidavit has been
affidavit.
filed, my lord. And, sorry, I'm sorry.
So it is very difficult to accept affidavits. And it would be very difficult when we deliver judgments and dictate the judgments.
In the consolidated, he may paginate everything and. file.
I have paginated, my lord. I have
Because
also
affidavits are not
paginated the
part of
consolidated
record.
petition. The annexure I have added and I have added it in seriatim so that the honorable court's record will not be disturbed. I have added it as A, B, C, D intervening pages. So the honorable court's page seriatim will not be disturbed. That I have already prepared. Because of the urgency involved, because the advertisement is on and the people are applying. So we are unable to apply because of this the
Already
indifference
here.
statement that has been meted to us.
Let us start hearing. Yes. Make your submissions.
My lord, may I be permitted to submit, my lord? Okay. Your lordship may kindly permit me to place the order dated 22/4/2024. That is at order number 10.
Yes.
I am reading the order your lordship has passed. Paragraph 2, the petitioners claim to possess diploma qualification in fishery science obtained from Agro Polytechnic Center.
Just a minute. I'll do it. The moment. In fact, Mr. Counsel, if we take up your matter today, it may take some time. So we can take up your matter day after tomorrow
Hello.
at 2 p.m.
Hello.
All right.
Hello.
Then other cases may be taken up. Otherwise, we may get stuck up in this matter.
Maybe, my lord.
I will also come up with a note.
Please come.
Ma'am.
And you also.
Yes, your lordship.
And you can file that in the list. List this matter on Wednesday. Wednesday to be taken up at 2 p.m.
This is regarding economic rehabilitation of the rural people, a scheme that was floated way back in 1980, my lord, and for a limited period. But nevertheless, my lord, since the petitioner's claim is that they have been there and doing cultivation for the last so many years, your lordship wanted to know whether the government has implemented any policy or not regarding that. My lord, in that I had a discussion with the Tahsildar. They need some more time to file a counter and to know.
Fine. Yes.
In fact, on the last occasion, my learned friend said that some policy has been framed by the government
Yes,
way
it
back
was
1
there.
year back. Let them file a
Because I need to file that on
counter, because
affidavit. I
without a
need to
counter, it cannot be heard.
As
Because they're already protected by your lordship's order, interim order is there.
as requested on behalf of the opposite parties plus state of Odisha. Is this matter on after reopening
After, yes, madam, that will be.
20th of June.
20th June.
Oh, bless me, yes.
Your lordship may post it the first week of July, because let them give the counter in the
July.
meantime, so first week of July.
Absolutely.
Because if they give me the counter, I may have to file rejoinder there too. First week of July.
It is expected
Before that, I'll.
that. This is matter on let counter affidavit be filed on behalf of the opposite parties by 21st or 28th. Is this matter on July completed?
And the interim order be extended.
Interim order shall continue.
of like.
समझ गए?
See that case, that 30 seat was allowed, permitted from like 2011 and continuing. It was enhanced from 2021 to 60. Now they said that, so this year they made the recommendation 30 is there, but so far 30, the rest 30 is concerned, there is some deficiency. So we wanted some time to, so Lordship wanted that why not 30, this at least 30 students will not be admitted to. They have filed an affidavit, they have said same thing. So whatever they have said in the impugned order, same thing. Recommendation has been made to 30 also, this year also. That is also kindly see their
But they say
paragraph.
that they will not allow.
They are not allowed. So that entire, the infrastructure, the staffs, the students. So for 30, there is no dispute right from 2011 till date. Only dispute is rest 30, 60. Or you also look to the,
Lord, I have served the copy of upload on my non-senior. But today, so I don't know, kindly see it, I will keep it. I don't know, kindly only for the reason. My lord, the ethics committee meeting, my lord, I have given.
Have you given a copy?
Yes, ma'am.
yes, yes, they have given the copy. It's just now they have given the copy, but
My lord, what the ethics committee,
say that recommendation for 30. They have said also, they have accepted that.
can I read, ma'am?
Hmm.
The committee approved introduction of new courses in existing, that is not, good, my lord, we come to the second, the OSD committee secretary informed all the members that the.
No, which item you are reading?
Serial-
Yes,
serial five.
5.
Page 9.
Five. Serial
Five.
five.
Page 9,
Yes.
clause 5, 9.
Yes.
I am reading the second paragraph, the OSD. The OSD Additional Secretary informed all the members that inquiry was conducted for 2 numbers of private PDIS institutions. That is Ingula Institute of Industrial Safety and Environmental Science, Jharpur, and Sivananda, the present one. Sivananda Institute of Industrial Safety, Honolulu. The inquiring officer recommended for reduction of seats from 50 to 30 in case of Sivananda Institute of Industrial Safety, Honolulu, that is Chilika, due to non-availability of adequate laboratory facilities and safety measures. Madam, kindly please turn over. Further, he gave the issue of maintenance of status quo reach numbers of seats as per notification number 3622 dated 27/7/22 of the SD and T department. The chairperson and other members of the committee, after detailed discussion and deliberation, unanimously decided to keep the admission in advance for the academic session 24-25, with Sivananda Institute of Industrial Safety, keeping in view the quality of education and safety of the students. This is one of the decision of the committee. So I have tested.
So this reason can be applied in all the institutions.
Well,
This logic can be given in respect of any institution at any point of time. Totally vague.
That day I submitted that I will place the reason. I don't know, kindly pass. Actually, the inquiry committee says 30. Now the same inquiry report being placed before the committee, Apex committee. This is the decision of the Apex committee.
So whether they have this authority,
Yes, ma'am. The Apex committee, the committee, all these things go to the committee and the committee takes the conversation.
it's a very serious matter.
Since 2011,
Yes. From the level they have been
the
taking.
entire thing is going on smoothly without
That's what I
any.
asked, ma'am. That's what I asked, how, if it is continuing from 2011, suddenly how can you then,
Then what is the possible reply they suggested?
the decision of the committee?
File it, we will see.
I,
And how this committee is constituted?
No.
The
There
what-
is a guideline. There is a guideline under Annex 1. There is a committee. It takes always the finals.
It is stated by learned DGA that a counter affidavit is in the process of being filed and shall be filed today itself online after serving a copy upon learned counsel for the petitioner. So list this matter tomorrow, retaining its position. Will you file any reply?
The same thing, the only record they have produced, this is the impugned order also. This only say that 30 recommended, but decision was taken like this. What more I can? The impugned order cheat, unexpected. No, that is not the impugned order. That has been reflected in the impugned order unaccepted.
Tomorrow. Let the registry ensure that the counter affidavit, which is to be filed today, is placed on record. This is something serious. How can they do that?
Examine the issue.
Why are you calling it on?
Tomorrow, yes.
Already verification was done with respect to safety measures in 2011 itself.
It's
So that was acted upon.
Three verification have been made. In the affidavit I have pointed out. Three inquiries were made and the petitioner or institution was given an opportunity to comply. That has not been complied. That has.
No. I'm not on additional 30. I'm on earlier 30.
Yes, earlier there was,
So
but there were
The-
deficiencies.
so far 60 is concerned, that is according to you, not 30.
No, see, recommendation was for 30.
No.
Now, chairman thinks that should not be allowed to admit students. And that, what is the basis for that thinking is not there on record.
And
Well, such persons should not chair such bodies. Because this is a very serious matter.
yeah, praise.
So, see, don't apprise. You're not required to apprise. But we want to know whether he or she is ex officio chairman.
the secretary is the chairman of that company.
It's very difficult. This person should not head such committees. It's a risk. Yes. Item 4. Next. Infructuous. It is stated by learned counsel for the appellate
Okay.
that with the influx of time,
2020.
this appeal appears to have become infructuous. Full stop. Is accordingly disposed of as having become infructuous.
C1
Item number 5.
Yeah, President.
Your Lordship, on behalf of conducting counsel B. Mahapatra,
Your Lordship, kindly some time may be given
Yes.
after vacation, Your Lordship.
Disposed of.
Hmm.
Six zero one nine of 2020. Check. No, 778 of 2020. 8 of 2020.
This appeal is not maintainable, madam.
As Your Lordship, conducting counsel is suffering from neuro problem, kindly, it is, even though it is not maintainable, he will
This is against dismissal.
kindly maybe after vacation. Maybe kept after.
Not after the question.
Then some time, maybe after 2 weeks, Your Lordship.
1 week. As because you are seeking adjournment on the ground of your senior, therefore, otherwise, we are satisfied that this appeal is not maintainable. As requested on behalf of the, we are of the tentative view that this appeal against an order dropping the contempt proceeding is not maintainable. Mr. Appellant counsel for the, it is appellant submits that when senior counsel who has to argue the matter is indisposed. Also, as requested, list this matter on 1 week, retaining its position. Yes.
Item number 7.
Just a minute. As requested on behalf
In this
of
case,
the-
notice has been issued. Already notice has been issued. Your Lordship may call this matter for admission so that it can be disposed of. He has appeared and delay has been condoned.
It has come for admission, fresh admission.
Fresh ad-
And why fresh admission?
My Lord, order 25/4. Sorry, 26/4.
The last order was that is the question. That's it. The learned counsel for the respondent seeks adjournment. So list this matter on. When? 2 weeks after holidays. Yeah.
Inter-
Holidays.
Interim order to continue.
Interim orders are continuing in the meantime. Yes.
Item number 8.
Your Lordship was pleased to direct my lord the state to give a response to the writ application.
How much?
CBA will also reply, and the state will also reply. Regarding the construction of an indoor hockey playground, in CBA and the dispensary minor, that is what they plan.
Indoor?
Indoor hockey ground, playground. The part of CDA, residential conflict, that is what they challenge. But the CDA will also answer.
CDA has been noticed.
CDA was not noticed. Only state was directed to file.
All it will say, as requested on behalf of the state. This matter on. After which.
Item 9.
Yes, Lordship, I am the virtual.
Yes.
Lordship, I am virtual. The matter may be, sir, your Lordship, matter may be taken up by next week. Due to my personal problem, the office brief is misplaced, for which I am unable to put forth the matter. Matter may be taken up, your Lordship, by next week. Any day may be fixed.
What is this matter about?
Your Lordship, the contempt appeal matter. Section 19 of the Contempt Code, but I am unable to put forth the matter due to my non-availability of office brief.
As requested on
Next week,
behalf
so
of
that I will.
matter on 1 week.
Item 10.
May I please, Your Lordship. My lord, this is the appeal filed against the Honorable Single Judge, Your Lordships. That is against the order dated 24/8/2022 and the subsequent order, Your Lordship, that is passed in the review. My lord, the order dated 27/3/2023. My lord, I have prepared a date chart. Your Lordship, may kindly see to ascertain the fact.
Yes, what is the question?
Your Lordship, may kindly see the date chart. Question is here, Your Lordships, whenever Act has come into force, but rules has not been come into force, Your Lordships. For giving appointment whenever assistant additional teacher is concerned. The Act says that the selection board has to be formed and therefore thereafter, my lord, the appointment will be given. Act came into force in the year 1989, whereas rule came into force in the year 92. But the appellant, my lord, who was given appointment on 27/9/90, you also may kindly see the date chart.
There is absolutely no legal infirmity in the order.
Yes, Your Lordship.
The appointment was to be made by a board.
No, my lord. The decision says, my lord, you Lordship may kindly see on 27/9/90, the appellant was appointed as additional teacher. 27/9/1990.
27/9/1990.
27 September.
Yes.
And 22/12/1990, managing committee sent proposal to block education officer.
22/12/1990.
My lord.
Then?
For approval of the service of the appellant.
Yes.
1/4/1990, the government of Orissa in school and mass education department decided to take all the ME schools of the state as government schools. 14/10/1996, block education officer Nimapada.
Why are you going through all
My
these
lord.
dates? Please come to paragraph 8 of the judgment.
Yes.
That is the crux.
No, crux is, Your Lordships, whenever, my lord, the case of the appellant is
You were appointed by whom?
by managing committee.
Under which provision?
My lord, the previous provision, my lord. Previous
Where is that?
rules.
Provision?
But previous rules before 1992, there was education rules. So managing committee had the power, my lord, to give appointment. My whole submission before Lordship is, whenever, my lord, Act came into force in the year
What is section? Oh, yes. When did the act come into force?
89,
89.
there was no rules, my lord,
Then,
for preparation of for formation of the selection.
then what is section 7B?
7B is the Act.
What does it say?
It says, my lord, you Lordship may kindly see the rule is provided here. Just I may be permitted to. You Lordship may kindly see page 27 of my brief. 7P says the state government or any officer or authority authorized by it may prescribe the qualification to be possessed by persons for appointment as teachers, including the norms relating to the requirement of such teachers in different categories of private educational institutions. Every private educational institution shall, in order to be recognized by the state government, appoint the required number of qualified teachers as provided in subsection 1 from out of the list of candidates select for this purpose by the selection board constituted under subsection 2 of section 10 in prescribed manner. So the prescribed manner is published in the year 92. The rule came into force in the year 92. Before that, I was appointed.
How were you appointed? You were appointed against the provision under section 7B.
No, my lord, but rule didn't come into force. Rule didn't come into force. In similar circumstances, a decision of our own High Court will suffice the matter.
Yes.
Two decisions, one is of honorable single bench and another is division bench. Your lordship may kindly come to this notice. It was in 1997, through OLR 120, another out as well.
So if your submission is to be accepted, then subsection 1 says that the state government or any officer or any authority is authorized by it may prescribe the qualification
Well,
to be possessed.
and whatever qualification now prescribed, I am sorry, I'm sorry.
So on the date when this act was enacted, no qualification was prescribed?
No qualification, my lord.
So anyone
Before
could
that,
have been appointed?
yes, before that, my lord, a qualification was there, requisite qualification.
Sir, please come to section 7B,
Again,
subsection 1.
my lord.
So if this is how you interpret the statutory provisions, then the effect of subsection 1 would be that you can appoint any person because there was no qualification prescribed.
But in the 89, my lord, by virtue of the act, qualification is prescribed, not in the rules, but in the act itself.
So
Whatever qualification, my lord, prescribed under the act in the year 1989, I had that qualification. And accordingly, my lord, the qualification, they don't dispute the qualification. They say, I have not come from a selection board. Only that is the order passed by the honorable single judge. In part of qualification, my lord, there is no dispute. I had a qualification.
That is not, it's a question of interpretation.
My lord.
According to you, no rules were framed in accordance, no board was constituted.
Yes, only my lord, they say that though I have not come from a selection board, so therefore, my lord, my post will not be approved.
So therefore,
they don't dispute the qualification.
This was your submission that since the board was not constituted,
right,
therefore you could be appointed by the managing committee.
Managing committee.
The question is, where did the managing committee have the power to select?
The previous rule, your lordship.
Previous rule will not apply after coming into force of this.
No, my lord, though new rules didn't come into force, then previous rules, that is the judgment, your lordship. I am now relying upon that judgment. That is the judgment. If rules didn't come into force, Patina Hoji Vivekananda Das.
Yes.
Well, here is a case, your lordships. Before coming into force of the act, that is untrained teachers, my lord. After commencement of the act, my lord, untrained.
Yes, you are relying on what?
My lord.
You are relying on what?
I am relying a decision, my lord, of this honorable court. Whenever rules didn't come into force, even if act is there, my lord, the previous appointment is valid.
What is that earlier rule? 74 rules or 90?
74 rules.
You are relying on which paragraph of this decision?
I'm sorry, madam. 120. Well, your lordship, straightway come to page 127, just
That is.
para 8. This is the finding of the para 8 of the judgment. I am reading that. In the foregoing paragraphs, we have noted that after the coming into force of the 1993 rules, there would be no scope for appointment of a person as a teacher without training qualification B.Ed. The 1993 rules envisages 2 grades in the service, junior grade and senior grade. The junior grade of service consists inter alia posts of assistant teachers of high schools. Recruitment to the post to the junior grade of service is made by direct recruitment, and promotion is provided in Rule 4.
Mr. This has nothing to do with your case.
I have, my lord, my case is, my lord, for all the aforesaid reasons, we have no hesitation to hold that prior to commencement of the Rule 1993 rules, an untrained teacher was eligible to be appointed against the trained graduate post with a recruitment that would not be entitled to draw trained graduate scale of pay.
That is different.
My lord, this is
Here the act provides.
here, my lord, act also came into force in the year 89. Same act, 1989 act. This rule, which is 93 rules, act is also 89 act. Before that, my lord, after 89,
What was there in 1989?
Yes, but in 90 also.
What was there in 1989?
89.
What provision was there in 1989?
That I had read before, lordship. The same act, requiring possession of qualification. Before 1989, after 1989, here a person was appointed as untrained teacher, but qualification was trained. Though, my lord, rule came into force in the year 93 regarding qualification, all these things, this honorable court held.
According to you, your appointment before coming into force of the rules was valid, and thereafter it became invalid.
Yes, your lordship. So that is, my lord, the decision.
That is not your submission. That is not your submission.
My submission is, my lord, whenever selection board was not in existence by virtue of a rule which came into force in the year 92, even if I was appointed prior to that, my lord, I will be considered for that. And another decision, the direct decision of course in the of honorable single bench. So that decision also says.
Procedure was changed after coming into force of this act.
Yes. You have that Amendment Act 89.
or 90.
No,
20
you have gazette notification of that.
amendment, ma'am, is the act. Act one is quoted in the order. In the impound.
Yes,
By my friend, it has already been cited before my response. Vivekananda Das, that has been distinguished letter in 99 in the case of Manmohan Tripathi.
We have
that we
taken
have
note of
taken
it.
note.
One. Number two, my lord, the submission that till 93 there was no is wrong. Madam, kindly see, as back as in 82, 81, the standard stuff was fixed with qualification later on therein. So that submission that.
No, he appeals. See, let us come to subsection 2. Subsection 2 of section 7B. It says every private educational institution shall appoint qualified teachers. This is 1. And non-teaching staff 2. By making selection in accordance with the procedure and criteria prescribed by the state government. It means that the procedure and criteria which have been prescribed or the selection, the procedure which was already there in existence, that procedure was to be followed as per this
Yes.
subsection 2. So it is not that the government had to, the schools had to wait for some criteria to make appointments.
Thank you.
So the subsection is very clear that based on the existing process, the existing procedure and criteria, the appointments were to be made. So what was the existing criteria?
Right with the Marot, this man is holding that book,
Yes.
which is at page 1088, I don't know. 1089.
Last.
Fourth clause, which fixes the standard staff for non-government secondary schools.
Yes.
Very good. Can you see?
89.
Yes.
I'm directed to say that the question of fixation of standard staff for the non-government secondary schools has been felt necessary by the government due to introduction of revised syllabus and maintenance new pattern. After careful consideration of various aspects, government has now been pleased to decide that the standard staff for teaching and non-teaching for different categories of non-government secondary schools shall be as follows. But the standard staff has been prescribed. And Madam, can you see?
No, the power was in whom of selection.
That is in the management rules, man. Now, I am only showing Madam what was the criteria. Qualification. Now, Madam will see that headmaster, trained graduate, trained intermediate, trained matric, classical teacher, Hindi teacher. Now, Madam, can you turn over?
Yes.
Out of the 2 science graduates, that is not relevant, Madam. For each of the, now, capital B is relevant. Next page. Capital BI. For each of the additional sections, in class 8, 9, and 10, 1 additional trained graduate teacher would be admission. Now, here is a case of additional teacher. In addition to, then 2, in addition to Supra, for every 3 additional sections of the above classes, 8 to 10, taken together, 1 additional trained graduate teacher or 1 classical teacher according to necessity of the addition. For each section, for class 7, 1 additional trained intermediate teacher of the addition. For each additional section for classes 4, 5, here we are dealing with high school math. Additional post of class. Now, my lord, this being the standard staff and he claiming to be an additional section teacher, he has to be a trained graduate, first of all, ma'am.
Yes, I am trained graduate.
Yes.
One. And two, my lord, his appointment could have been made when the school was private. Once the school was brought into the fold of granting aid by the government, the managing committee cannot appoint any further.
When was the school taken over?
Here,
They're 91.
This standard pattern of 1981, 82, 81
81.
has suffered amendment also. In perhaps in 91 or 92.
In 91, rules have come.
No, this standard pattern. This circular,
My lord,
this is a circular,
my lord.
executive instruction. This has been modified subsequently. Not modified. Perhaps sitting single, I have dealt.
For fourth peer, my lord is referring to fourth peer, yes, for fourth peer. Because in pursuant to judgment of the Honorable Supreme Court.
The school was taken over in 1991
My lord,
and his appointment was made before that.
my lord, prior to that, the school was aided. He could not have been appointed.
No, he says he has the qualification.
Even if he has the qualification, my lord, management could not have appointed him.
Why?
Because once the school comes into the fold of granting aid, the management has to either take prior approval for appointment.
Where is that?
That is in the rules, man.
When were the rules framed?
First, the first rules came in 1974, then 1991.
So 1991 will have no application because he was appointed in 1990.
Man, may I take notes to 1974 rules?
Where is that? Where is education matters? Yes.
My lord, in this book, this is at page 976. The nomenclature is, my lord, the Odisha Education Recruitment and Conditions of Service of Teachers and Members of the Staff of Aided Educational Institution Rules, 1974.
Yes.
My lord, may kindly come to
Yes.
Rule 8.
Yes. Yes.
My lord, exceptions to selection board, selection by the board. Nothing in these rules shall apply to posts filled up by persons on deputation from government. Notwithstanding anything to the contrary in these rules, it shall not be necessary to apply or to submit an appointment made by the managing committee of, that will be or governing body to the selection board if the appointment is made on ad hoc basis for a period not exceeding 3 months. The vacancy in a post, now the next B, the vacancy in a post carrying higher scale of pay is filled up with prior approval of government in case of a college and the concerned director in case of an institution other than a college by an employee of the same institution who possesses, or we are not concerned, it is a higher post. Promotion. Now, my lord,
No,
upon
but where are the other provisions? 4, 5, 6, 7.
that has been
3.
deleted now.
When?
Deleted on 1/10/92.
Therefore, those provisions are important
I will,
because his appointment is of 1990. So if they were deleted in 1992, then those which were applicable in 1990, before 1992 will apply.
my lord, I just now read rule 8 to my lords.
8 cannot be read without 6, 7, 5.
Then I will,
For the reason that it provides exception to the selection by the board.
no,
So there must be provision for selection by the board.
no. He's not covered by that because he says selection board was not functioning. So managing committee appointed me.
No, therefore, we will have to see what was the provision prior to. In fact, section 7B does not say, does not rather say that the selection procedure, unless the procedure is prescribed, no appointment shall be made. It simply says that in accordance with the procedure prescribed. So whatever procedure was prescribed, whatever procedure was existing on the date of enactment, that procedure was required to be followed. So this is the procedure according to you, these rules.
Yes, I have a old book, my lord. I will
Please show tomorrow. And show us, where is that?
Yes, ma'am. Your lordship may kindly see a judgment I am referring to.
So judgment we don't read,
Ma'am.
unless you show us the law. Without law, we
Yes, your lordship. Your lordship is
futile exercise to read judgments.
ma'am. That rule is prescribed
Tomorrow?
day after tomorrow.
No, tomorrow.
Item 11.
May I please? Like here, the appellant has challenged the order of the learned single judge, my lord.
So which order is under challenge?
Annex 1, my lord. The order passed by the honorable single judge, my lord.
Yes.
Lordship, the dispute here is which will have more weightage, my lord, whether the voter ID card and the electoral roll or the school admission register or the matriculation certificate, my lord. Lordship, here I will only show one documents here, my lord.
Mr. But why didn't you file election petition? Why you have come? Why did you file a writ petition?
Well, as per the act, my lord, as per 26(2), my lord, it is, Lordship, kindly have a glance at the rules, my lord. My lord, rule 26(2), my lord. Rule 26(2). May I place, my lord?
Read it.
My lord.
Please read.
Yes. The collector may suo motu on or on receipt of an application under subsection 1.
Mr. It was an election matter.
Yes, my lord.
Election was over.
Yes, my lord.
The candidate was returned.
Yes, my lord.
Then where is the question of you are for the appellant?
My lord.
You are for the appellant.
Yes, my lord. My lord, in the writ petition, I was for the.
So the election petition was the only remedy.
My lord, simultaneously, my lord, simultaneously under the Gram Panchayat Act, my lord.
Right. Should not have been entertained.
So that's why as an appellant.
My lord, the question of maintainability has been answered by the learned single judge, my lord.
What? That it is maintainable.
Yes, my lord.
No,
What is?
we have held contrary. In Gram
Madam?
Panchayat Act, we have held in division bench. I was party to that.
It is. It
We
cannot be maintained.
My lord, but the learned single judge had held that it is maintainable, my lord.
Therefore, you are here.
My lord.
Therefore, you have challenged.
Yes, my lord. Therefore, my lord, I am in a writ appeal, my lord.
All right, we will not, when do you want? No, not 1 week. 1 week will, as requested on behalf of the respondent, but you are also seeking adjournment.
No, my lord. I am ready, my lord.
He is ready. And why should we be adjourned? We are of the prima facie view that the writ petition was not maintainable. By way of last indulgence. There is, at the request of counsel for the respondent, the matter is adjourned to 1 week. Yes.
Item 12, oblige, my lord.
May I please your lordships? My lord, the impugned order under annexure 4 is challenged here. Your lordship may kindly have a glance to page 18 is the impugned order. And the relevant portion is, my lord, the ordering portion is at page 23, paragraph 6. Considering the rival submission made by the learned counsel for the parties, this court is not inclined to entertain this petition. Accordingly, the petition is dismissed, no order has to pass. That is the observation made by the Honorable Single Judge. Fact of the case is that, my lord,
So what is wrong?
my lord,
What is wrong in the order?
this Honorable Single Judge has not assigned any
Is
reason.
there any reason?
Yes, ma'am. No reason. And secondly, my lord, your lordship may kindly have a glance to annexure 1, page 11. That is the
No,
order passed by the Odisha Administrative Tribunal,
There is nothing.
Cuttack West, that is in the previous writ application,
Paragraph 5.
the previous OML. May be permitted to place the annexure 1, my lord.
The appellant was engaged as Shiksha Karmi. So, Shiksha Karmi when? In 1993.
1992.
In 1992. So, he approached this court by filing a writ petition challenging an order passed by the Director Elementary Education, Odisha Bhubaneswar, rejecting her application for reinstatement on the post of Shiksha Karmi since her service was dispensed with effect from the date she had remained absent from the school. Full stop. Then single judge has dismissed the writ petition on the reasoning that as the post of Shiksha Karmi was already abolished, comma, petitioner's case for her reinstatement could not be considered. Stop. And single judge has also noted, comma, in the impugned order, comma, the stand taken on behalf of the respondents that the scheme for appointment of Shiksha Karmi or Shiksha Sahayak was abolished on 31/1996. And therefore, her claim for absorption as primary school teacher against vacant post of primary school teacher could not be entertained. Stop. Next. We the present rate appeal has been filed. Yes. We do not find any legal infirmity in the impugned order passed by the learned single judge requiring this court's interference in an intra-court appeal. This appeal is devoid of merit and is accordingly dismissed. Yes.
Item 13.
13, my lord, I pray you can take up tomorrow.
Tomorrow.
Max.
Why?
That's
All right, tomorrow.
5.
Item 14. That the present appellant was selected for the post of Jogan Sahayak, securing highest mark in the selection test, and she was not given appointment on the ground that Sarpanch stated that he is not a permanent.
Where is the order under challenge?
And the order dated, Honorable Single dated 18/10/2013 at page 50.
15.
Yes. Annexure 4 at page 48.
Yes.
My lord, you will also kindly come to page 57, my lord. Paragraph 17, 18.
7.
17, my lord. 17. Court's
Which is the
reasoning
order
and
under
analysis.
challenge?
Yes. According to the learned counsel for opposite party, the advertisement clearly stipulated that the candidate should be a permanent resident of Gram Panchayat. Scrutiny of the applications were made by the opposition 5 on 25/4/2016.
Also, you are referring to which order?
The order of the Honorable Single Judge, my lord.
Where is that?
That is the Annexure 5 I have annexed.
Is this 30?
Annexure 4. Annexure 4. At page 48. In paperless, my lord, in the paper, my lord, there is a difference about paging of the.
No difference.
No difference, my lord. At page 48.
Yes, yes.
Your lordships can come to page 57. Court's reasoning and analysis. May I place my lord order? According to paragraph 17, according to the learned counsel for the opposite party, the advertisement clearly stipulated that the candidate should be permanent resident of Gram Panchayat. Scrutiny of the applications were made by the opposition 5 on 25/4/2016, and merit list was prepared by the on the 27/4/2016, wherein the petitioner along with Khetraman Panigrai, Dhaneshwar Jani and Tapano Santa were shown as 1 to 4 respectively. At the same time, the Sarpanch of Tenadi Gram Panchayat raised the allegation that petitioner is not a permanent resident of the concerned Gram Panchayat
and she had not submitted recent residential residence certificate with respect to her abode. Para 18. As the certificate filed by her had no force till the date of scrutiny. This is important point. No force. As the certificate filed by her, this appellant, had no force till the date of scrutiny, the opposition file issued a letter number 87 of 2016 dated 29/9/2016 to the petitioner and by asking her to produce her recent residence certificate by 2/10/2016. But she failed to produce the same. Thereafter, the opposition file also served another copy of such letter to the husband of the petition in front of the post office of the village Ikamba. The petitioner and her husband received the such letters, but they could not submit any such certificate afresh, shown that petitioner is resident of concerned Gram Panchayat. Moreover, the villagers of the village Gudiapadar and other Sarpanch said village have separately given in writing that the petitioner never stayed in the village Gudiapadar. Since the petitioner is not a permanent resident of same Gram Panchayat, even though she was found to be a number 1 in the merit list, but she was eliminated in the panel list of the selection to the post of Jogan Sayak as is not a permanent resident of village Gudiapadar under Telana Dinga Gram Panchayat. As such, the non-appointment of petition to the post of Jogan Sayak of Telana Dinga Gram Panchayat is illegal and the petition is liable to be dismissed. My lord, one of the conditions that one should be the permanent resident of that Gram Panchayat, my lord. As per the Orissa miscellaneous certificate rule, I submitted my residence certificate issued in the year 2012, my lord. That is a permanent certificate. There is no time limit or invalidation of the certificate. Your lordships kindly see that proof, my lord. I am giving the book to your lordship. That has been repealed in 2017, new rule came into force. In new rule, validity is 1 year. But in the Orissa miscellaneous certificate rule 1984, there is no validity of certificate, it has a permanent validity.
It's a question of fact, whether you are permanent resident or not.
I have given the certificate, my lord. I have given the certificate along with my lord, my Aadhaar card, my electoral roll, identity card, my passbook, everything I have given. I am a permanent inhabitant of that village. Thereafter, my lord, when they asked me, I applied for that. I got the certificate, and in new certificate, my lord, I am permanent resident of that.
You are relying on what?
Pardon?
You are relying on which provision of this?
But that certificate has only that rule 3, perhaps rule 3, it has been said that the residential certificate shall be given under that rule. And there is no provision that the validity of the certificate, the period of validity of certificate, has been given in new rule.
No, where is that? Which rule you are referring to?
I am rule 3, my lord.
Rule 3?
Yes. Certificate rules, rule 3. You will also under that rule, only the residence certificate shall be granted, my lord. You will also income certificate, residence certificate, everything has been provided there. It is a permanent certificate. No validity is there. And validity period has not been provided in the said rule.
So a person who gets a certificate.
Yes, under that rule, he is a permanent inhabitant.
If he goes to United States, he will remain. If he becomes citizen of United States, he will remain a resident of that.
There are other documents are there. There are other documents.
How can you say it's how can you make this submission?
Well, that is certificate I have given at the time of.
Then there is nothing permanent. Once the certificate has been given, therefore he shall remain resident of that place. Very, very difficult submission.
While that in the new rule, your lordship can see that validity has been given.
Sir, therefore we gave you this example. that if a certificate is given under that rule, and the person moves to United States
Yes.
and becomes citizen of
Yes.
United States, he shall remain the resident of Gram Panchayat for the purpose of everything.
Here, my lord, I have given
Completely,
the,
it's a question of fact.
I have given the certificate, the latest certificate.
That has been looked into.
And also the Aadhaar card I have annexed, my
returning.
lord, given the recent certificate, my lord. I am a resident of that village. Your lordship, I will come to page 40. Besides 2012 certificate, I have given the certificate this on 1/7/2017, my lord. After communication, I made application, my lord. The process is there, procedure is there as prescribed under Rule 6 of 1917 rule. And
When was the selection over?
selection, my lord, I was selected. They have not, selection was 2000.
When was the appointment met?
Appointment was not made, my lord, till today. Has not yet been made, my lord. Your lordship, kindly come to page 44, my lord. I'm placing that document. This is to certify that Aparajita Mahanti, wife of Hitesh Kumar Jena, of village town Gudiapada, PS Umarkot, in the district of Nabarpur, in the state of Odisha, and his year family ordinary resides native in the village town Gudiapada, post Ekamba, PS Umarkot, Jharigam, district of Nabarpur, issued by the additional Tahsildar Jharigam.
So when was the selection made?
Selection they have made 2016 on the basis of my previous residential certificate, my lord. That selection, after selection, I remained on serial number 1, my lord, securing highest mark, my lord. Then I produced, my lord, that Aadhaar card. Your lordship kindly come to page 43, my lord. This is my Aadhaar card. It is I belongs to village Gudiapada. Then previous page 42, 41 page. That is electoral election commission, the identity card. I am the inhabitant of village Gudiapada, my lord.
All these documents you obtained after
Yes, I have produced all the documents.
all the documents you obtained after the selection process?
No,
was
no,
over?
these documents are prior to that, my lord. Prior to
It's come to
selection.
Annexure 5.
Annexure 5. To the repetition, my lord.
No, Annexure 5 here, page 41.
41 is. 41, my lord. That is 41 is, my lord, that is election identity card, election commission identity card. The 17 was 2017.
This is what we are saying, that these documents you obtained after the selection process was over.
That was there, my lord.
That was there. Then why
No,
did
that
you
was
keep
not
the
there,
submission?
my lord, at that time. Aadhaar card is there, my lord. Aadhaar card also that it has been issued.
Now come to page 42.
42. The bank account.
Yes. So when was this opened? 2018.
18, my lord. 2018.
Should we impose cost?
That, my lord, then
And you
my
are
lord,
making incorrect submissions.
sorry, my lord, that was
Only
issued.
because we are giving liberty. You should
That
not misuse that.
certificate I have produced later on. I'm actually permanent inhabitant, my lord.
Actually, we are not here to decide actually.
My lord, that
Actually,
certificate 17/2017, your lordship, I'll see the procedure. How can the certificate is to be obtained when after communication?
All right, dismissed. Order.
That
Next,
certificate
item 15.
2012, my lord, that validity has not been taken away, my lord.
Next.
Item number 15.
Petition challenge the buyers of the rules, annexure 5, page 32, my lord.
Is there any rule framed by this, framed in the state of Odisha which has not been challenged? Any rule, any act?
Now
There
government has
should be some
amended.
research.
This challenge, my lord. So far prayer is concerned, the government has amended the rule, my lord. Government has filed an affidavit.
Now what do you want?
There are two prayers, my lord. Also two my prayer number 1 is meted out, my lord.
Would you challenge the constitutional validity of Rule 15?
Yes, my lord.
That has been amended.
Amended, my lord.
Then what is the?
My second prayer, my lord. The amendment made in prospectively, my lord. So far, I will not get benefit. Let's just see the affidavit filed by the government advocate.
Yes.
Let's see the affidavit, my lord. Paragraph 5 of the affidavit, my lord. Affidavit 5 by the government advocate.
Is there?
Page 3 of the affidavit, paragraph 5.
Affidavit is not there, huh? Affidavit is there. Yes, it is there.
Yeah. 20th April.
Yes, what is the matter about?
But they have the amended rule, they have annexed, my lord. The amended portion, my lord. Rule 2.
Was framed when?
Let's first on to.
You are challenging Rule 15 of 2013.
Yes, madam.
And this has been amended.
This has been amended. The portion I have challenged, that portion has amended, my lord.
So now you want that this amendment should be retrospective. From 15, from 15.
I'm citing to decision.
Citing decision.
Let's it on to paragraph 35 of that. Paragraph 35 at page 358 of the judgment. May I please it, madam?
Yes.
Paragraph 35, madam.
35.
Yes, Mr. As page 358 of the judgment, paragraph 35.
Yes.
The court's opinion is forfeited by the latest amendment brought about on 3/6/2020. This clarifies beyond doubt that even for the post of junior engineers, those individuals holding higher qualifications are eligible to compete. In the opinion of this court, though the amending rules were brought into force prospectively, nevertheless, being clarificatory, they apply to the recruitment that is the subject matter of the present controversy. Such a position, that is clarificatory amendments operative retrospectively, despite
Retroactively,
retroactive,
not retrospectively, it is retroactively.
retroactively, sorry madam, despite their enforcement prospectively,
has been held in several previous judgments of this court. In Jail Singh versus State of Haryana, this court examined the various authorities on statutory interpretation and concluded such and such. In paragraph 13 of that Jail Singh judgment matter, 13 and 14,
Yes.
it is a cardinal principle of construction that every statute is a prima facie prospective unless it is expressly or by necessary implication made to have a retrospective operation. But the rule in general is applicable where the object of the statute is to affect vested rights.
All right,
or-
forget, what are the facts?
That, my lord, in Rule 15, they
Who
impose
are
the-
you?
we are selected for undergoing for appointment as forest range officers by the Odisha Police Forest Service Keeper. Selection was made by the Odisha Public Service Commission.
Direct.
Direct, my lord.
Yes.
After appointment, Rule 15 prescribed at the previous, which before amendment, my lord, will on successful completion of the training, will be appointed and training period will be not counted for the purpose of service. That I challenge the Harris. Now government has amended it. Government has amended it and said that period will count for service, but and I will get the salary, my lord. But the amendment prospectively, amendment was notified on 13th March 2024, but this shall come into force on the date of their publication in the Odisha Gazette.
Yes, he appears to be correct.
No, that is my paragraph 5. That since the prayer meeting restitution has already been considered by the state government by amending the regulatory provision of 15 by allowing the trainee to get salary and other allowances during the training period as admissible by the government of Odisha from time to time, for which the prayer made in the restitution has become infructuous. That's what I said.
You
can clarify that.
Yes, sir, clarify that. I will get.
The petitioners were appointed against the post of Odisha. Oh, sorry. What is that post?
Oh, Forest Range Officer.
Or appointed as forest range officers. Which is a Group B post.
Yes, Odisha Forest Service Group B.
Group B post under Group B post regulated by Odisha Forest Service Group B, bracketed recruitment and conditions of service rules 2013. Stop. They were sent for training. They are required to undergo training for a period of 18 months in a which college?
Forest College.
Forest College, Angul.
In Forest College, Angul, to obtain diploma in forestry. Stop. Rule 15 of the said rules, where is that?
Page 36 of the writ petition.
Page 36. 15 of the said rules. Where is that? 15 what?
First, rule, page 15, rule 1 and rule 4, both are challenged. In rule 1, sub-rule 1, the finally selected candidates shall be required to undergo 2 years training in a recognized forest college to obtain the diploma in forestry. During the training, selected candidates shall be granted each a stipend as may be fixed by the government from time to time. Only stipend. Then rule 4, my lord, sub-rule 4. On completion of training, in the forest college, the candidate will be considered for appointment.
Rule 15 of the said rules, read as under. So, the virus of Rule 15 has been put to challenge in the present writ application to the extent the same provided grant of stipend instead of salary to the selected candidates during the period of training. Stop. The and counting of where is
Training
that?
period as if it is in service.
Yes, I think so.
Sub-rule 4, as can be noticed from the said rule, it provided that the candidates would be considered for appointment to the service. उसके बाद वो लिखो से rule 15 virus of rule 15 has been put to challenge to the extent it provided for grant of stipend in place of salary for the training period, and the effect of sub-rule 4 and effect of sub-rule 4 whereby the period of training was not to be counted for the purpose of computation of period of service. So, where is the affidavit we have? The state government 74.
My copy.
They're not there.
74 as 70.
70.
That is digital page 98. Bookmark.
An affidavit has been filed on behalf of the state of Odisha, wherein it has been specifically stated. It has been stated that the state government has decided to amend the rules, and with the issuance of amend Rule 15 of the rules and the same has been amended by notification dated 13/3/2024, published in the official gazette on 15/3/2024. Namely, Odisha Forest Service, Group B, open bracket, recruitment and condition of service, close bracket, open bracket, amendment, close bracket, rules 2024, wherein it has been provided that the finally selected candidates shall be required to undergo 2 years training in a recognized college to obtain diploma in forestry, and during the period of and during training, the trainees shall be paid salary and other allowances as admissible by the government from time to time. Stop. It has been stated that in view of the amendment effective from the in view of the said amendment, it is the stand of the estate that since prayer made in the writ petition has already been considered by the state government by amending relevant provision of Rule 15 by allowing the trainees to get salary and other allowances during training period, paragraph 6. No, it's not. Admissible by the government of Odisha from time to time, for which the this writ application has become infructuous. First off, the state of Odisha, it is the stand on behalf of the state of Odisha that the present writ petition may be disposed of as having become infructuous in view of the amended provisions under Odisha Forest Group B, recruitment and condition of service amendment rules 2024. Stop. Next, learned counsel appearing on behalf of the petitioner has raised an apprehension that the petitioners may not get the benefit of the amendment made in 2024, and they may be denied of the benefits, treating the said amendment to be retrospective in nature. Stop. He has submitted that since the said amendment is merely clarificatory in nature, this court may require the state government to implement the amended provisions in case of these petitioners. Stop. He has placed reliance on Supreme Court's decision in case of Punit Sharma and others versus Himachal Pradesh State Electricity Board Limited and another reported in 2021 volume 16 SCC 340. with a special reference to paragraphs 35 to 39 thereof. So stop next. In view of the clear stand taken on behalf of the state of Odisha, that in view of the amendment brought in the year 2019, 2024, in view of 2019, 24, in view of 2004, the writ application has become infructuous, we dispose of the writ application with an observation that the petitioner shall be entitled to the benefits arising out of amendment in Rule 15, bracketed 3, amendment in Rule 15 of so-and-so rules by amending rule का नाम लिख दोगे. Application stands disposed of.
Item number 16.
Sir.
Indulge in private practice. I have had a discussion with the give it some time to solve it. Give an exhaustive content.
It's a policy matter.
Please permit me to speak in Oriya. सेदिन ऑर्डर गला पर बर्तन मेडिकल ठीक चलची तंकर गोटे कमिट करछंदी आठने कमिट करिया परे जहा रोगी माने बहुत खुशी अछंती सेमान को आउ से भला हैरान
They have taken steps. They have taken steps. Private practice has been banned or stopped.
Stop. And जो मेडिकल छाड़ी पळौथिले सेटा भी बंद हे जाईची बर्तन रोगी माने बहुत खुशी ओडिसा रो प्राय 4 कोटी लोक माने
performing their duty within time. The time allotted to them, they are performing their duty.
वर्तमान प्रेजेंटली चालीस तापर कोन हो कहि होनी जे तो हाई कोर्ट निर्देश के सुनिला परे से दिन सारे जहा कले सब लोक माने ओडिसा रो प्राय समस्त खुशी होइछंदी एवं समस्त भगवान रक्षण सारंगर मंगल कामना पे जाओ बढ़िया गरीब लोक माने बहुत उपकृत होइछंती जे जो मेडिकल रहु नथिले लोक
This is the scenario in entire Odisha.
गोटे जिनस हवा कथा जे डॉक्टर माने जो आफ्रंट पिनदु ड्रेस कोड आउ डिस्प्ले करछन जो नेगी गोटे गोटे बड़ बड़ बोर्ड रे सब मेडिकल प्राइवेट हॉस्पिटल सामने रे मन करन अश्विनी पाखरे विराट बोर्ड लिखा जी एसी मेडिकल प्रोफेसर अमक मेडिकल प्रोफेसर एसी मेडिकल अछन लिखि सब निजर जो डिस्प्ले करछंदी एवं कमर्शियल हे जाइछंदी डॉक्टर भगवान सेठी निवृत्त रहया पे मु ओडिशा हाई कोर्ट को निवेदन कर प्रभु चीफ जस्टिस
रिक्वेस्टेड
ना ना विड्रॉ करियो कहीं पब्लिक को पे मु चाहूची जेहेतु समस्त पब्लिक उपकृत हो
as requested on behalf of the state of Orissa, discuss matter on when do you want?
On behalf of the common people from downtrodden.
1st July. First.
Please, Your Lordship, this matter, the stamp reporting has not been made, noting is there. But if Your Lordship, and then that is the contempt appeal, my lord. This is the.
You have been convicted.
My lord.
You have been convicted.
Convicted. This is a
You have filed appeal against an order passed.
by
in a
the
contempt
honorable
proceeding.
single judge, my lord.
Have you been convicted by the order?
Yes, my lord. By the order, because I agree, because your lordship, the order, your lordship see, that is 55, page 55. The contemptor has admitted that there is a violation of the order.
Mr. Counsel, appeal can be entertained only if an order of conviction is passed.
Not conviction, but the contempt has been dropped.
Contempt,
Even
then
if,
that appeal will not lie.
my lord, this is how the petitioner will get the relief,
How
my
then
lord.
that
The
can be seen by the legislature. We
the
cannot.
Contempt of court act, my lord. There's the imposition of penalty is there.
Please read Contempt of Court Act. Do you have Contempt of Court Act?
Section 12, my lord.
The difference between you and we judges is very simple.
Yes.
That you have memorized the provisions of law and we don't remember. So therefore you are not required to have books with you. And every time
I think that is a stamp reporting has not been made.
Stamp
In case-
reporting.
That's why
So
this
when
might
you-
be adjourned.
When
That's
you
why I have not come.
when you appear before a court, you should have
Yes.
at least the bare act with you.
Yes, yes.
We are not satisfied. We are dismissing it.
Sorry, man.
No requirement of any stamp reporting. In the present. Field. Under section 19,
Well-
bracketed 1
Punishment for contempt of the court act, 12, section 12.
of the Contempt of Court Act 1971. The petitioner has put to challenge, petitioners have put to challenge an order passed by a learned single judge. Where is that order?
Page 55, madam. Once your lordship see, that is page 54. That is annexure 6.
Chilika?
Contemptor has admitted he is guilty, madam.
Single judge. Dated 6/10/2016. In CP number 28C of 2019. Order dated क्या है? 6/10/2000. Order dated 6/10/2016.
No,
2/11/23.
2/11/23. Where is that
Digital
order?
page 66. Digital page 66.
Contempt is an independent nature, but he has, this honorable single judge has dropped in accordance with the order of the petition.
Where is that order?
Sir, digital page 66.
The order challenged,
Sir, bill number-
page 55,
Serial tickets.
and dear lordship, see. 55, 56, 55,
That is-
15.
Order dated. Challenge.
56.
To challenge an order passed by a learned single judge of this court dated 2/11/2023, passed in CONTC bracketed CPC number 28 of 2019, whereby the learned single judge has dropped the contempt proceeding. Stop. The an appeal under section 19 of the Contempt of Courts Act lies against an order of learned single judge in exercise of the jurisdiction to punish for contempt. So stop. In the under section 19, and no appeal under section 19 lies against an order dropping or refusing to initiate contempt proceeding.
19(3) also.
So stop. This appeal in the court's opinion is not maintainable, it is accordingly dismissed. Oh, so AKIR. No appeal lies defined. Bracketed C 2000. 2015 SAIR 2015 Supreme Court 1831.
My lord.
Midnapur.
Although not Midnapur, the other decision is not. I got the information another case. Was 1988 volume 3 Supreme.
1988
volume 3 Supreme Court case at page 26 now.
Decision.
Page
26 now.
26. What does it say?
91 says no, so again this automatic law appeal maintainable.
Oh, but if you read the section,
No.
please
Any
read
order
the-
goes into.
Huh?
Any order goes.
in exercise of
Yes.
power to punish. So that power to punish is there, and in exercise of that power, that is still the Supreme Court has it.
Midnapur, I think that is the latest clarified entire position.
Section 19(3) says that any person agreed by the order of this and he can file a appeal.
19(3) refers to 19(2). And again, we are saying that you can make your submissions because of your talent without the bare act in your hand.
And
That is the
willful
advantage you have.
disobedience. That part, willful disobedience has to.
Item number 18.
My lord, I mobilized my. I'm sorry, my lord, appearing in virtual mode. My lord, in this case is a contempt. Lordship may remember that one official of defense is appeared. We have already complied with.
All right.
We need 7 days time to file an affidavit in this Lordship may dispositum.
If the order has been complied with, we can drop it.
As per my
Yes,
instruction, it
my-
is yet to be complied.
We
No
have
pension
received
has been
the
paid.
signal from the defense, the concerned officer showing me But I didn't have the written instruction or anything.
It
in
is
this
stated by learned Deputy Solicitor General for the Union of India that this court's order violation of which has been alleged in the present contempt application has been complied with. So he seeks adjournment to file a compliance affidavit in this regard. So this matter on 2 weeks.
Mobilization.
So as to enable him to file before summer vacation. 20th of May.
Fine. Mobilization.
Item 19.
19 of the right over there. You will make time to obtain the instructions.
When the officer has the presence of power.
PBS order name.
Item 19.
So, right over there, 6th of April, please to hand me 2 weeks time to obtain instruction regarding compliance. Because this is the direction was for disposal of the representation law. The collector is in also within that election, so here requested for that time lawsuit. Before the holidays, we can lawsuit put it.
And requested on behalf of the contenders, this matter on 21st. So as to enable AGA to inform the court about compliance of the order, violation of which has been alleged in the present contempt application.
Item number 20.
Obliged.
If he has any merit, then it's all right.
Here, I am the appellant.
Therefore, if there is no merit, then there is no question of adjournment on her ground.
Because she has requested me yesterday that she will take
I have
time.
requested on behalf of the respondent list this matter on. When do you want? 1 week.
You're also fixing it
1
tomorrow.
week.
Item 21.
The impugn order here is not considered the judgment of the Honorable Supreme of this Honorable Court confirmed in the Supreme Court in the meantime, and I have also filed it before the Honorable Single Judge. That is why the impugn judgment was passed. But had this judgment would have been considered, the order would have been otherwise. The fact of the case is like
seek review.
But it can be disposed of. If my lord will allow me 2 minutes on.
No. See, if you had cited that decision.
Yes, that is in the additional. I have annexed that. I have annexed those judgments. But the Honorable Court has said not spelled out a single one.
All right.
And finding is contrary to the judgment of the upheld.
What is that? What is the finding?
What? Only one line, my lord, from the impugn judgment, my lord, page 97 of the first brief. The common judgment, my lord, 4 cases. Common judgment. That para 31, last line. Hence, the career advancement policy of the Shiksha Sahib cannot be applied.
Page
97.
97, yes. Paragraph
31, last line. Only on one line.
Yes.
It says, hence the career advancement policy of the Shiksha Sahib cannot be applied to the present petitioners. Present petitioners, Gana Shikshaks. Actually, the judgment is otherwise. Judgment of this Honorable Court in Dhananjay De's case, upheld by the writ of appeal and as well as the Honorable Supreme Court, there says the Gana Shikshak are to be at par with the Shiksha Sahib. And these particular judgments, I have annexed it as Annex 8, 9, 10 in the writ petition. That was not been considered anywhere. Well,
that period spent.
the Gana Shikshaks, they got a circular, after 8 years, they will be regularized. But the judgment of our own High Court says no. They will also be regularized after 6 years. If they are trained. We are trained. We have been regularized. Subsequently, government has withheld it. I came to this honorable court. In the meantime, Dhananjay's judgment has come, wherein this honorable court has said no. They have to be regularized on 6 years. They have gone to the writ appeal, and as well as the Honorable Supreme Court, the state has lost. All the judgment I have given. That judgment I have filed to the Honorable Single Judge, but that was not considered. But now they have implemented that judgment also. In case of the other cases, except these few, throughout the state, my lord, they are implementing this Dhananjay's judgments. And all the Gana Sikhyaks, those have trained, they are now being regularized. I have also given one of such example.
One of the cases, I think, Mr.
No, but what is this observation?
Your submission that instead of 8 years, we have made it
6 years. Yes.
We consider because of the possibility of the government to have reduced to 6 years, but completely 6 years, single just direction in that case of 8 years.
That was the.
So we modified
Yes. I want that much of. Then I have filed it. I have filed it. Kindly see, my lord, is the record. That is in, I filed it to the court in the Honorable Single Judge. In WPC OAC 416 of 2016.
No, but why, what is the meaning of this observation? Qualification of the petitioners does not conform to the requisite qualification of Shiksha Sahayak as per the Government Resolution 587 dated 10/1/2011.
That is the 10-1 resolution has taken note of in, that is the, my lord, I will with respect, my lord, say there is a wrong finding. Because subsequent in Dhananjay's case, that has been clarified. Qualification is almost one and the same, my lord. Yes, yes.
Qualification is to be treated at par with this. So that is why we are saying that this department resolution has subsequently been taken care of in that judgment.
Yes.
This
yes. If I don't permit, I will clarify the
resolution.
text. Yes.
This resolution has been, effect of this resolution has been diluted.
Yes.
By
the judgment.
By the judgment.
Yes. If my lord will permit me, I will clarify the facts. What happened, my lord, without opening. My lord, what happened? The government has the policy in 2000 to recruit, instead of the direct recruitment to the primary school teacher, they want to recruit Sikhya Sahaks. Those Sikhya Sahaks on completion of 6 years, first 3 years they will be treated as junior teacher, further 3 years they will be regular teacher. That means all 6 years they will be regular teacher. This is the policy from 2000. Prior to that, my lord, there was a policy of education volunteer. In all these primary schools, they were recruiting education volunteer. So they have scrapped that policy. What they have done, all these education volunteer brought into the same establishment in the nomenclature Gana Sikhyak. There a policy has come for this Gana Sikhyak, they will discharge the same duty in the same school. But there is a policy they have brought in that only after 8 years, they will be regularized as regular teacher. Sikhya Sahak 6 years, well, they're 8 teacher. So this was the policy. But in that 2013 policy, there was a scheme, there's the same parameter for the scheduled caste, scheduled tribe, physical challenge candidates, they will be regularized after 6 years. We are the scheduled caste candidates here. Accordingly, we have also been regularized in 2014. But subsequently, they say, no, we'll have it after 8 years. So our regulation was cancelled. I went to the tribunal. At the time that Odisha Administrative Tribunal was there, there was an interim order. We continued. In the meantime, my lord, all those other Gana Sikhyaks, they directly come to this honorable court. In that Dhananjay's case, there the honorable court has taken note of all the circulars, including the 2011 circular, what my lord have read it, and come to a conclusion. There is no difference between Gana Sikhyak and Sikhya Sahak. They are in the same parameter. On completion of 6 years, if you have the training qualification, then Gana Sikhyak will be regularized.
That was the submission of learned AG before the Honorable Apex Court.
Yes, that was accepted.
Mr. So, Advocate General appearing on behalf of the state contends that since the respondent petitioners had the option to seek regularization and as they did not do so, they cannot claim the benefit of reckoning their services for the period they worked as Gana Sikshak.
Yes.
That was
That was
clarified by
clarified.
the Supreme
Yes,
Court.
but the honorable Supreme, no, sorry, honorable, first the honorable single judge has said on completion of 6 years, they will be regular. It is regular teacher at par with Sikha Sahib. They have gone to the writ appeal. The writ appeal confirmed the honorable single judge order. Against that, my lord, the state went to honorable Supreme Court, and Supreme Court will also confirm the order, division bench order. So this is now the position is, my lord, that after all these things, my case was taken out. So, but I have filed all these judgment as annexed to my additional affidavit also. But this judgment was not taken out of. That is the only.
Yes,
Only
state
now
will
this.
File your affidavit. You will not decide without affidavit.
Yes, ma'am.
No, it can be this. How can it do?
Light of what has been observed in by the Supreme Court. That is also very important. The, if you notice, let an affidavit be filed on behalf of, accept notice on behalf of the opposite parties. Let an affidavit be filed on behalf of the state within when do we want? 2 weeks.
Item 22.
Yes. Yes, what have you filed? You know, is no. It is stated by Brand AGA that in the light of this court's order dated 15/4/2024, an affidavit has been filed.
On my 2nd May.
2nd May. 2nd May order is not there.
I filed on 2nd May.
On 2/5/2024, which is not there on record. So this can matter on 1 week. The said affidavit on record. You have received.
I have not received that affidavit. I'm a affidavit dated. OP5. OP5.
We have clarified that we have taken step and a review, a draft resolution is prepared, and that has been vetted to the GA department. GA department observed some discrepancy. Thereafter, we have complied it and we have tried to send it after aggregation that the final resolution is possible. And then we are going to handle that or will be compliant. It will take some time. That's the application.
The government has filed a draft, prepared the common cadre, and that was filed before single was just in contempt number 8037, madam. That was there, madam. So they have already prepared that affidavit. Your Lordship may direct on, because the learned single judge has directed the government to progress, go ahead with the Prevalatra South case.
We will see on the next.
Yes, sir. Till then, my lord, till then the interim arrangement was made, madam.
Item 23.
So my name may be reflected because I have entered appearance, my name is.
Name.
All right, sir.
Item not 23.
If I may, Your Lordship, praying for an adjournment.
You always pray for adjournment. Not very encouraging. Try to make your submissions also.
Lordship,
What is there? What is the merit? As
Your
requested
Lordship,
on behalf of the petitioner, list this matter on. When do you want?
Your Lordship, an adjournment for,
When?
Your Lordship, after vacation.
After vacation.
Matter.
Obliged, Your Lordship.
Item note 25.
Solicitor General was supposed to obtain instruction in the matter. Last date, that was the order passed by my lords.
My lord, I'm sorry, my lord, this in spite of my repeated instruction, I didn't receive any instruction from the ministry.
No problem.
Either Mr. Paddy is seeking adjournment for this or.
No, he has failed
So in
to
that
have
case,
instructions. So we will have to decide it without instruction.
Lord, in fact, your lordship has taken note of the provision of law in the last order. On that basis,
Lord, it can be disposed of any time as your lordship direct the revisional authority to dispose it of. Let the interim order continue till disposal of that case. That's all.
No, no, what is the matter?
Lord, yes. In fact, I am challenging that order. Lord, I have shown that rules to my lordship. I have a right of filing a reply. This is that mining revision, my lord, where on account of non-filing of rejoinder, the interim order got vacated on the single day. And I had shown to my lords that rule 36 sub rule 2. Lord, I have got a photocopy of that relevant rules if your lordship will find it. That rule is here, my lord, rule 36. Or your lordship has got the book, my lord. Rule 36 sub rule 1 is not, that's the provision regarding giving notice and filing of sub rule 2. Comments received from any party under sub rule 1 shall be sent to the
Which
other.
rule? Which rule?
My lord, this is mineral other than atomic and
36.
hydrocarbon. Mineral concession rules 2016. But I have taken a photocopy of that relevant rules. Instead of lordship taking pain to find out from book, I have given that. If the lordship is holding the same book, it is at 485. Page 485.
412.
But 485 this book. I have given the photocopy of that relevant rules. But you can see it from that.
Rule 36,
Rule
order on
36.
revision application.
Absolutely correct.
Yes.
Rule 36. Should I be permitted to place it now? On receipt of an application for revision under Rule 35, copies thereof shall be sent to the state government or other authority and to all the implicated parties, calling upon them to make such comments as they may like to make within 3 months from the date of issue of the communication. And the state government or other authority and the implicated parties, while furnishing comments to the central government, shall simultaneously endorse a copy of the comment to the other parties. 2. Comments received from any party under sub rule 1 shall be sent to the other parties for making such further comments. This, my lord, I am coming under. Further comments as they may like to make within 1 month from the date of issuance of communication, and the parties making further comments shall be sent to the other parties. But here I received the comment. 26th of February 2024. Through an email. That is page 36, madam. Page 36, annexure 14.
Yes.
26th of February 2014, annexure 14, page 36. I received the comment. So I am entitled to, at least after receiving the comment, this period, I am entitled to file a reply to this. But for the first time, it was taken up on 12th of March 2024. After 26/2, it was for the first time taken up at page 15, my lord.
Yes.
Page 15, it was taken up, and I applied to grant me little time. But then Learned Revisional Authority, instead of granting time, vacated the interim order which was passed earlier in my favor, my lord. That is page 34. This is what, after looking at that rule 36(2), it has struck to the mind, and your lordship was kind enough to protect my client. That is the position as we stand today, my lord. Lordship can dispose of the revision, saying that it can be disposed of within a period of 15 days, 10 days. That will end the matter.
We have third learned senior counsel appearing on behalf of the petitioner and Mr. Padhi, learned Deputy Solicitor General for India. What's up? Learned Deputy Solicitor General for India has informed this court at the outset that despite best efforts made by him, he could not receive any instructions from any instruction or receive the requisite instructions from the
Minds.
concerned opposite parties. Full stop. The petitioner has put to challenge, in the present writ application, an order dated 12/3/2023 and 24, passed by the revisional authority.
That regional authority come additional secretary to government.
Additional secretary come revisional authority, government of India, Ministry of Mines, New Delhi. Dated 12/3/2024 and a subsequent later dated 1/2/2024 issued by the Deputy Director of Mines, Baripada. Stop. Next, since despite opportunities granted to the opposite parties, no counter affidavit has been filed, we are left with no other option but to decide the present writ application based on the averments made in the present application. Stop. It is the next, it is the petitioner's case that the petitioner is a lessee.
Lessee.
Where have you said?
I have said not the lessee. Yes, ma'am.
Is a
Lease of
lessee.
Godwa and Mangalajodi.
Huh?
Bloodship sees.
Paragraph 6.
Right. Para 6.
No.
Lease of Gondwa and Mondajodi iron ore and manganese ore mines. Just above para 6, the two lease these iron.
Have you mentioned?
In fact, it is Lordship sees not directly, but they say that on 18/5, the lessee revisionist who is the present petitioner Virat Chandra Dagara filed 3 revision cases. It is only said that lessee. Para 6.
Petitioner, lessee had filed a revision application under section 35 of the minerals bracketed other than atomic and hydrocarbons, energy minerals, bracket closed, concession rules, 2016, against an order made by whom?
By the competent authority regarding lapsing of, my lord.
Where is that order?
That order is not here, my lord. That order. It is, my lord, by the deputy
Oh,
director.
Mr. Let there be pleadings, otherwise it will be difficult for us to write an order.
Right, my lord. That lapsing order.
Otherwise, we don't know,
Right.
you are lazy in respect of what?
Lord, lapsing order should have been filed, but it is not filed, my lord.
What is this matter on? 1 week. Within first 5 cases, so as to enable and counsel for the petitioner to file an additional affidavit.
That I'll file. I'm sorry, my lord. I troubled my lord.
Matter fixed for 2 p.m. hearing, item number 71.
May I please, your lordship? This is a case in which I have appearing some of the fishermen and non-fishermen community, lordship. We have our pond at the beach of Chilika, lordship, and some of our pond has been demolished by the Tahsildar Chilika and Tahsildar Tangi. Lordship, there is a circular of the district fisheries officer Khordha. Both these Tahsil Chilika and Tahsil Tangi, that is under the collector Khordha and also the district fisheries officer Khordha. There is a circular that without before doing the demolition of this pond, there should be a demarcation, lordship. That letter is there with me. Can lordship just go through this? 13647. Let's just have a glance to the last portion of this. Sorry, one copy. Lordship, in this case, the district fisheries officer Khordha has given a direction to the Tahsil Tangi and Tahsildar Chilika that before doing any kind of demolition to the pond, particularly recorded land pond, lordship, they have to do the demarcation. That letter is there. I hand over to the learned courtmaster. The last portion of that order, your lordship, have a glance. Last portion.
In this case, what is the case number? 7469.
13647, lordship. The
case number of this case is?
Yes, lordship. There are number of cases are there in this case, and particularly
Which case you are concerned amongst these cases?
Lordship, 13647, the IA number that is pending before the lordship. In this case, what has happened?
Where is it?
163.
Which
13647, lordship.
Which page of the cause title?
That is a IA number that is pending before you.
Yes, which page of the cause list shows that number? So that we can open that brief.
Brief, lordship.
Do you have the cause list?
Lordship, I have my
Last case. Yeah. 13647. That is WPC. This case. What is the repetition number?
Lordship, the repetition is
136
it is so much of PIL initiated by the Honorable Court. It is there are number of IAs, intervenor application, and
No,
this is
number
a,
of WPCs are also there.
yes. I am also petitioner in one of the
So
repetition.
which one you want us to open?
Lordship, I am asking this interim application apart from the repetitions, the interim application that is 13647 by
In which case you have filed?
21.
In the
Lordship.
main case?
Yes, in the main case.
In the
In the main case, Lordship. In the main case which has been moved by the Registrar General Judicial Lordship.
Portable flag 208.
208. What is this PIL about?
Lordship, this PIL is about there is a public interest litigation pending in the Supreme Court. That is in 2003 in Balkrishnan case, Lordship. This matter has been taken up by the Honorable Supreme Court in 2017. Division bench of the Honorable Supreme Court, that is consisting of Justice Madan B. Lokur and Justice Sinha, both of them, they have taken up this matter, and there was a direction that how many wetlands are there across India that is to be preserved and protected. In this case, Lordship, Chilika being a wetland, so that came. Thereafter, the Registrar General of Orissa High Court, he has so much initiated a PIL for protecting and preserving the wetland of the Chilika area, Lordship. That is the whole case about, Lordship. What has happened, Lordship?
What is your name?
Lordship, I am Akshay Vishal, Lordship. My client is Dushasan Patra. He is having a small patch of land bordering to Chilka Lake. That is his recorded land, Lordship. By virtue of this circular, which
you are arguing PIL or some private interest?
Lordship, it is an intervenor application. In the PIL,
please sit down. Please sit down. We will hear you later.
Lordship.
Who is pressing the PIL?
Lordship, pleased to appoint me as the amicus in this case. If I may just give a brief background of the case.
So someone is appearing for this Odisha Wetland Development Authority and Odisha Coastal Zone Management Authority.
The state is representing.
No. Indian.
Odisha Wetland Development Authority.
Someone is appearing.
For Chilika Development Authority, Mr. Pradeep Kumar Mahapatra is appearing.
I am from the Chilika Development Authority, not Wetland.
And for Coastal Aquaculture Authority.
So what is the difference between Chilika Development Authority and Chilika Wetland Development Authority?
Chilika Development Authority has been constituted to protect the ecosystem and all around development of Chilika Lake, and a lease of that prawn culture and everything in the district administration is looking after. So Chilika Development Authority is look into the water lake sea, the only ecosystem and all the.
So the entire PIL is for you.
No, man. The prayer is for entire wetland of Odisha.
No.
Two wetlands.
Two wetlands.
Not Chilika.
No, Chilika is there.
Two wetlands in Odisha, Lordship. It is one is Chilika and other is Bhitarkanika. There are two wetlands in Odisha.
Ramsar Convention.
Yeah.
In Odisha, there are two Ramsar Convention. One is Bhitarkanika, another is Chilka. Bhitarkanika. There are two Ramsar Convention in Odisha.
What is two?
Ramsar Convention. Ramsar Convention, Lordship.
Ramsar Convention.
Convention.
What is this?
Ramsar Convention sites. Ramsar is a city in Iran where the first meeting took place to conserve these wetlands, and India is a signatory to that convention.
Yes. So the report which was submitted by you.
Yes, Your Lordship.
Whether that takes into account this Bhitarkanika also?
Yes, Your Lordship. Both Chilika and Bhitarkanika.
Where is that?
Your Lordship, at flag 3, 6 issues have been identified which are concerning these two wetlands. At flag 3.
Many orders have been passed.
Yes, Your Lordship.
What is the outcome?
Yes, Your Lordship. Now, the Honorable Court is taking up 2 issues. That is, one, illegal prawn culture, and second is the pollution of these 2 wetlands.
And two is pollution.
pollution of these two wetlands.
Yes.
Now, Your Lordship, the prawn culture is such like there are two types of prawn culture, one within the lake and one outside the lake. Within the lake, the prawn culture is what they do is that they make a net and they surround the lake and they do the culture there. And after the culture, the water is left to the outside the lake, which completely pollutes the lake. And towards the land side, earthen pit is dug up, and within that, water is drawn from these lakes, and prawn culture is done using chemicals and all hazardous things. And after the culture is done, that water is again released back into the lake, which destroys the lake. So these are the two types of culture takes place. And this honorable court had directed for satellite survey of the extent of area within which this illegal prawn culture is happening. And it came out that upon an area of 26,000 acres, this thing is happening. So thereafter, various orders have been passed to demolish all these illegal ponds within the lake and outside the lake. But it was seen that once this is done, the very next day, within a week, those illegal things again came up. So it was not quite effective considering the huge area of the lake, Your Lordship. So this honorable court then had directed that each of the 3 districts within which the lake is confined, all those districts will deploy a drone, and drone surveillance will be taken up on regular basis to see that the demolished ponds do not come up, Your Lordship. And the district collectors were directed to submit a report on each and every date when this case is taken up. So for this date, I don't think that the district collectors have given a report.
So this matter was, when was this matter taken up last?
Last is 19th December 2023. Thereafter, the orders were passed, but the effective order was, Your Lordship may see, 19th December 2023. Heard Mr. Ashok Kumar Parijal, Learned Advocate General, along with Mr. Devakant Mohanty.
Which order?
19th December 2023.
Yes.
Heard Mr. Ashok Kumar Parijal, Learned Advocate, Mr. Devakant Mohanty, and Mr. Ishwar Mohanty. Your Lordship may go to. Now the entire PIL is focused on this draft Chilika policy to be prepared and finalized by the state government, Revenue and Disaster Management Department. In this regard, several dates have been posted and several directions were issued to the government to prepare the draft Chilika policy after consulting and after having the bipartite discussions with fishermen and non-fishermen societies. That Your Lordship may see, para 5. In view of such position, since some time is sought for by the state, this court grants still.
Yes.
Para 5. Grants time till 30th January 2024. By that time, Learned Advocate General assures to place on record the affidavit reflecting the developments that will take place and the discussions that will take place with different stakeholders, so that this court can be appraised of such position and pass necessary orders in accordance with law. So the state was directed to place on record what is the development, what are the discussions held with the fishermen and non-fishermen society with regard to finalization of the state Chilika policy, draft Chilika policy. That affidavit we have filed, and Your Lordship has taken note of the same by order dated 30th January 2024. Order number 82. Mr. Ashok Kumar Parijal, Learned Advocate General, contended that in compliance of the order dated 19/12/23, he has already filed an affidavit. Let copy of the said affidavit be served on Learned Counsel appeal for other contesting parties within 3 days. Please the matter after 2 weeks.
In that order, we have observed that draft policy was getting ready.
Getting ready and discussions are being held with the stakeholders.
So
then affidavit was placed on record as per the direction
That is noted in the order dated 30th January 2024. And after that, or perhaps there is no. Still. Thereafter.
Affidavit on behalf of Collector Khorda.
No. I'm just. On behalf of Sri Diganta Rautray, working as Additional Secretary to Government, Revenue and Disaster, on behalf of the government, state government.
Affidavit filed by
Diganta, OP number 3, that is dated 29th January 2024. 29. The deponent is Diganta Rautray.
29/2023.
29 January 2024.
That is filed with Tahsildar Chilika.
No, my lords. That is another, your lordship may see, that is the affidavit by Additional Secretary to Government Revenue Department, Diganta Rautray.
No such affidavit. Hmm?
Wait, not from the report. Yes. Lordship may kindly see flag 248. 248.
Yes, digital page 7938. On behalf of opposite party number 3.
Yes, ma'am. Yes. The deponent is Diganta Rautray, Additional Secretary to Government, Revenue and Disaster. Lordship got it? Yes. The status as on that date was reflected in this affidavit, and thereafter also there are developments.
Yes, what is the development?
After this affidavit, the developments, there are also other developments which my non-friend will submit. That's what.
It's the deliberation that had taken place with regard to framing of the fishing policy. In the meantime, my lord,
Just a minute.
please.
So this is of 29/1/2024.
Yes, 29th January 2020.
What happened after this?
Please, my lords, if my lords may see the minutes of the meeting, which was held on 20th of January 2024, which my lords will find at
Yeah.
will find at page 59, my lords.
You are representing whom?
I'm representing the government.
With me,
sir.
his state. His
State.
additional
Please,
standing council. Yes.
Your additional standing council.
Please,
Yes.
For the state.
for the state. My lords, in that meeting, because my lords, the Department of Fisheries and my lords, the Chilika Development Authority had also co-opted two experts to deliberate on this issue. And they have also been part of the meetings before. And my lords, the
Who are those experts?
my lords, one Mr. Dr. V. Sampath and my lords, Dr. Ritesh Kumar. Dr. V. Sampath is a fisheries expert, and Mr. Ritesh Kumar.
What is he?
Well, as Mr. Ritesh Kumar is Director, Wetland International, South Asia.
What is this? Director Wetland International?
Well, as, this is an international organization which is
It's a private organization.
it's a private organization. So the Chilika Development Authority had appointed him as an expert.
So where does he live?
He lives outside Odisha. He's in India. So they have been attending the meetings, and also they were in their reports they had said that they would want to take some field visits, because unless they meet the stakeholders, they wouldn't be possible for them to. And in the previous affidavit, they had indicated a timeline by which time they would give the reports. Because after the reports are given, the state, then it will be presented to the state government.
So what was the timeline?
Because the timeline was about 4 months. They had sought for 4 months. Now, in the meantime, my lords, since my lords, in March, the Model Code of Conduct came into being. Thereafter, my lords, going to these villages and having these meetings are a problem, my lords. So therefore, my lords, they have intimated that they would request some another month's time after the results are after June, because they are not able to do the field visits. Because for the field,
how the election and their visits there?
No, because for the field visits, my lords, they have to go and meet the villagers, and for which, my lords, the district administration also has to, my lords, get all the villages together, and then only then they can meet the stakeholders, and that is, my lords, the difficulty now. So since March, my lords, they have not been able to do any field visits.
And otherwise, which law regulates these things? Which law? Which act? Which provision?
There is a coastal regulation zone which is,
No,
under the Environment Protection Act,
The Environment Protection Act.
under
Let
the
us see which act is that.
It's the Coastal Aquaculture Authority Act
No,
2005.
Let's see.
Because apart from the Coastal Aquaculture Authority Act, which, my lords, gives the licenses for fishing, the Environment Protection Act also, my lords, take care.
All right, let us see, let us understand. We are trying to understand what is the violation, and which is the forum, which has the statutory responsibility to ensure protection. So let us see. Otherwise, we cannot proceed on general knowledge.
Lords, here, my lords, in Chilika, my lords, there has been an historical issue of, my lords, fishing rights being given to traditional fishermen and, my lords, non-fishermen, who are not, my lords, fishermen by caste, because fishermen, and so, my lords, so therefore, my lords, to regulate as to how a fishing policy will be developed and who will give the license. So that is, my lords, the endeavor which is being undertaken.
That is very small exercise. The bigger issue is of protection of Chilika.
Please, my lords, the ecosystem of Chilika.
Yes, that is the main issue.
Please,
so far their rights are concerned, you're taking a policy decision. You are in the process of that. You may do that, but this is larger issue.
Please, my lords, this policy would also, my lords, therefore, my lords, the experts which have been
See, your policy, we are in 2024.
Please, my lords.
And this High Court had initiated this suo motu proceeding in 2017.
Please.
So what was required to be done by the state authorities, the High Court is doing. And you are still in the process of finalizing your policy. And it will take further 2 months' time or 1 month time after the elections are over. Meanwhile, we will see what can be done. Let us examine the statutory provisions first. First of all the persons who are statutorily duty bound to do what is to be done for the protection, they will have to do it. Please. Do you have a copy of the act?
I have one copy.
I had supplied also one copy, I think there is a record.
You had supplied? Yes, last time I remember something like this was given. No.
2023 Amendment Act has already been commented. After.
So for the purpose of this act,
Yes.
Coastal Aquaculture Authority Act 2005.
Yes.
Some of the provisions of the Environment Protection Act shall not be applicable.
Yes, Your Lordship. Overriding effect passed.
Okay. Environment Protection Act. So whether the authority has been constituted under the act?
Yes, your lordship, authority is working.
Who are the members?
There is a chairperson consisting of a retired High Court judge and
Yes. What is the name?
lordship, yes, the learned counsel for the Union of India may say he has recently, someone new chairperson has been appointed.
Yes, who is appearing?
Mr. Party.
Chair is appearing at least.
Chair is left blank.
Honorable Mr. Justice Amar Singh Chauhan is the chairperson.
Come to section 11.
Yes, your lordship, the functions of the authority.
So all these have been done.
Yes, your lordship, the authority is registering the farms and undertaking all the registration activities through the district collectors.
No, the regulations have been framed.
Yes, your lordship, the rules are there. Coastal Aquaculture Authority Rules 2005.
Come to section 13.
13, yes, your lordship, the process for registration of the farms.
What is the coastal regulation zone?
That is defined under the area within which all commercial activities are prohibited.
Please come to section 13.
Yes, your lordship. Registration as well.
Yes. Yes.
And section 12 provides for the process for demolition of the structures, the illegal structures.
13.
12, your lordship, section 12. The power to enter, remove or demolish.
Yes. Yes.
These are the main provisions of the statute. And the persons intending to take this coastal aquaculture, they have to register their farms with this authority, and only then they can do it.
So this Chilika lies in this within this definition, coastal regulation zone.
Yes. Chilika lies within this the definition of coastal area, your lordship. Section
Coastal
2,
area.
Section 2, subsection D. D. Then note number 2. D, note number 2 of section 2D.
No, but this section 13 refers to coastal regulation zone only.
Your Lordship, section 13, subsection 1. It says, save as otherwise provided in this section, no person shall carry on or cause to be carried on coastal aquaculture in coastal area.
No, further, coastal area.
Or traditional coastal aquaculture in the traditional coastal aquaculture farm, which lies within the coastal regulation zone referred to in subsection 9 and is
So
not.
this is second.
Yes, Your Lordship.
This is second.
Second.
Carried on coastal area 1.
1.
Coastal aquaculture. No person cause to be carried on coastal aquaculture in coastal area 1.
1, yes.
Or traditional coastal
aquaculture in the traditional aquaculture farm, which lies within the CRZ.
No. Sir, cannot read it like this. Save a cause to be carried on coastal aquaculture in coastal area 1.
1, yes, Your Lord.
Or traditional coastal aquaculture in traditional coastal aquaculture farm 2, which lies within the coastal regulation zone. The coastal regulation zone is very important.
Yes, Your Lord.
So this is what we are trying to understand.
Yes, Your Lord.
That to apply section 13, the area must lie within coastal regulation zone. What is coastal regulation zone?
Your Lordship,
Defined.
it has been defined
To mean the area declared as the coastal regulation zone. In the coastal regulation zone notified, the notification issued by central government under Environment Protection Act 1986 and includes such other area as the central government may by notification. You have these notifications as per clause D of section
clause
2.
D. Yes, Your Lordship.
You have it.
No, Your Lordship.
You have it.
Lordship, can
Where is that?
Your Lordship,
Chilika?
the first paragraph. Now, therefore, in exercise of powers conferred by clause D of subrule 3 of rule 5 of the Environment Protection Rules 1986 and all other powers vesting in this behalf, the central government hereby declares the coastal stretches of seas, bays, estuaries, creeks, rivers, and backwaters which are influenced by tidal action in the landward side up to 500 meters from the high tide line, and the land between the low tide line and the high tide line as the coastal regulation zone.
So what is this in exercise of powers also conferred by clause D and subrule 3 of? Please read it.
I think your lordship is reading coastal regulation zone 2011.
2011.
2011 your lordship is holding.
And after that also that has been amended. They have rectified. Frequently they are coming with modifications, Lordship, without.
Latest is of 2009.
By reducing the area.
No, what is this? It's a park.
Rule 5 of the.
Now, then. Must be subsection.
I3D is a rule or act, from section of the art, Lordship, that is. Act, this rule specification of sub rule 3 of rule 5.
There is no-
Notification.
There is no D.
Something was to do with the 6 months back. Computer should be not.
Anything within shape. Section is, or clause D. Exceptions, deleted so and so. Nothing contained in this paragraph shall apply to coastal. Of this act.
Coastal Aquaculture Authority Act 2005.
Validation. It's anything contained. Because your lordship, in the CRZ notification, the prohibitions are there.
No, what is the effect of, have you read 27?
Yes, sir, Lord.
What is the effect of that? Nothing contained in the apply to coastal ecology.
It says after paragraph 2, after subparagraph 13, the following subparagraphs shall be inserted and shall always be deemed to have been inserted, namely, nothing contained in this paragraph shall apply to coastal aquaculture.
So nothing in Rule 5 shall apply to coastal aquaculture. So this, the environment protection rules, they are not to be applied for the purpose of this.
No, Your Lordship, because this is a self-contained act.
All right, it's a self-contained act, but where is this 13? Fourteen can come only after 13. Rule 5(3). Section 3, yes. Five of subsection 3. Or clause D of sub-rule 3 of 5. So clause D of sub. D of sub-rule 3, clause D. After something following subparagraph. Where is this notification? No,
Yes, Your Lordship, I'm not getting it that.
Do you have this notification?
No, Your Lordship.
9th February
Dated 19 to 1991.
No, Your Lordship, this I'm also not getting it.
So therefore, we are trying just to understand whether we have to apply this Environment Protection Act and the rules at all or not with respect to this area.
Yes, Your Lordship.
If that is so, then we will not read these provisions for the purpose of the present PIL. Are you sure?
Indeed, Your Lordship. I will get back to Your Lordship on this one.
This provision has advanced. So all the provision. That we have to confine ourselves to this act only.
Yes, Your Lordship.
So where are the regulations framed under subsection, under this clause A of subsection 1 or section 11?
Yes, Your Lordship. The Coastal Aquaculture Authority Rules 2005.
Rules and regulations both are there.
Just a minute, let us understand. So these rules are not under section 11.
It has been framed under section 24 of the Act.
Section 24.
Yes.
Yes. And regulations?
Section 26.
Huh?
25 and 26, under section 25 and 26, the regulations.
Oh no, regulations are to be framed by the authority.
Yes, Your Lordship.
All right. Then come to B. Inspect coastal aquaculture farms. So whether this is being done?
Yes, Your Lordship. Because of the orders of this Honorable High Court, various teams have been formed by the collectors of each district.
The collector has no role, the authority has to do.
Is the authority through the collector, they are doing it. Because the collector is the head of the district level committee formed for the purpose of registration.
All right. Let us come to C.
See, such other things as may be prescribed.
To register coastal aquaculture farms. This is being done.
Of section 11C. Yes, Your Lord. To register coastal aquaculture farms.
This is being done.
Yes, Your
All
Lord.
right. And D, to order removal or demolition of any coastal aquaculture farms which is causing pollution after hearing the occupier of the farm. Whether this authority is a party or not.
Yes, Your Lordship, the Union of India is representing the authority.
Coastal Aquaculture Authority is a party, and we have already filed counter affidavit. Taking note of that, we have only the supervisory power.
You have all the powers.
Yes, yes. Including.
And despite you, the High Court has to take up this matter.
And we have filed the counter affidavit also that in the meanwhile, retired Honorable Justice Sri Amar Singh Chauhan has been appointed a chairperson, including all the member secretary has been appointed. Because of non-appointment, that issue was earlier there, but in the meanwhile, they have been appointed.
When?
On 6th December 2021, that is the notification.
And the secretary, who is the secretary?
Secretary Dr. V. Kripa is the secretary who has shown this affidavit.
Where is the affidavit?
That is we have filed since 2021. That is that. It's 2021. That is at flag, my lord.
Your opposite party number 11.
Subsequently, we have been added as opposite party.
What is the constitution? Where is that affidavit?
That is my red flag, I think. 250 road affidavit. 249 or 250. Affidavit filed on behalf of OP number 1 is at 249 and
May.
7291.
Just a minute.
Digital page. Vikripa. Vikripa.
subsequently.
Yes. Please tell us.
I'm a poor man. I have my 2 acres of land. That is nearer to Chilika. Let's see, direction was that the district fisheries officer direction was to, before doing any kind of demolition, do the demarcation. That I have seen here. Let's see. In this case, let's see, there was a direction of this honorable court.
No, if you are aggrieved by any decision, you can file a writ petition, not in PIL.
No, I'm not, it is not a PIL, let's see, because many farmers, they are affected. In the process, it is not one application, many around 100 of intervenor applications are there.
100 of intervenor applications cannot be decided in the present PIL. If any action has been taken, you can file independent. The directions in this PIL are general in nature, are being issued from time to time. So if any action of the authorities, which according to you violates any statutory provision, then you can take recourse to law. You can file, if appeal is provided, you can file appeal. If appeal is not provided, you can file a petition.
Your Lordship, just have a glance.
But we are not here to decide all the intervention applications, deciding your rights. Otherwise, the entire exercise will become, see, everyone will come to intervene in this proceeding, questioning actions of the authorities.
Lordship,
That liberty you will have.
Lordship, have a glance to the order date 23rd September 21, Lordship. Just have a glance. 23rd September 21, Lordship. Order dated 23rd September 21.
So it is taking 5 minutes for me to reach to the order sheet in the digital form.
And Lordship, may I read that order, Lordship? 23rd, that's it.
Let me try it.
What is the date?
23rd September, Lordship.
21st.
23rd.
Third.
23 September. 23rd September 2021.
156.
Lordship, copy of the order sheet is there with me.
What do they want?
That is only issue notice status.
Yes, Lordship. Your Lordship, IA number 13647 of 21, issue notice. Lordship, as he then was Mr. M.S. Sahu, learned additional government advocate, asset notice and 6 time to submit
after instructions, a copy of the petition is served on him. Status quo shall be maintained by the parties till the next.
No, we will vacate the status quo. You can challenge. It is, Mr. Counsel, it is impossible if the court continues with the PIL and at the same time starts deciding all the intervention applications on merits, then the entire exercise will become futile.
Let's see.
So we will be deciding those matters instead of taking up the public interest.
Let's see. What has happened? The high tide line, what the state is raising, Lordship, HTL, high tide line. Ponds, those who are nearer to the high tide line, within 100 meters of the high tide line, that is they are taking the steps to demolish all those. Lordship, what I pray, can this honorable court set up a commission who can go at our cost?
In this, an extra 3.
Lordship.
We are rejecting. What is your IA number?
13647 of 21, Lordship.
1?
13647 of 21, Lordship.
Oh?
Of 21, Lordship. Lordship, what has happened? Actually, the high tide line, what they are telling,
Mr. We cannot enter into such aspects. If you are aggrieved by this order,
Lordship,
you
at
can
our
challenge this
cost,
order.
what I pray, at my cost, Lordship, on commission be sent, I'll deposit the cost as per the direction, Lordship.
Mr.
On commission report,
Please try to understand the scope of this proceeding.
Lordship, let it be lie over till the final disposal, Lordship. I lie. Because what all other IAs are there, let it be lie over till all the decisions are taken in all these IAs. Because many other IAs are also there pertaining to this issue, Lordship.
So all the IAs will be dismissed, disposed of. We don't know. Because we are not deciding your intervention applications on merits. It is impossible for, and it will not be proper also. That if we take up one matter in the nature of public interest litigation and decide cases of like removal of encroachment. Now everyone will file that the order passed by the circle officer or whosoever is incorrect, Tahsildar is incorrect. Now go into the merits of that case.
Lordship is asking me that if I have any personal grievance, I can file separately.
You can file whatever. Because this order has been passed, has this order been passed in the light of particular direction given by the court?
Let's see. To maintain, state is to initiate demolition of the ponds, those who are within 100 meters of the high tide line.
All right. So how many applications are there? How many applications?
So many intervention applications.
So many, all the intervention applications, one by one will have to be.
Applications, the personal issues have been raised.
It is not the same issue, Lordship. But I am.
We cannot go into such.
This status quo
We have
order.
not violated. We have not.
No. That has not been extended.
That has not been extended. Yes, madam.
Check up.
No, that has not been extended.
And where is this WPC 7469?
That is the main case. Let's show what appear.
That is the main case.
That is, and numerous IAs are there.
Lordship, in this main,
there is only one writ petition.
Lordship, that is 746.
Only one.
That is 7469, Lordship.
All right.
Lordship, I am only confining to this my IA because different IA has been filed for different prayer, Lordship.
We will see.
If your Lordship is asking me to vegetate my grievance in separate treat, I can do that,
You
Lordship.
can do that. The present public interest litigation registered suo motu pertains to safety of the biodiversity and ecology of the water bodies by restricting aquaculture in accordance with the statutory provisions under Coastal Aquaculture Authority Act, 2005. Read with Coastal Regulatory Zone Notification 2011, bracketed 1, bracketed Roman 1 and bracketed Roman 2. Government of India. ऐसा लिखो. Read with the government notifications issued under the said notification. Date, comma with particular reference to the two water bodies in the state of Odisha, namely Chilika Lake and Bhitarkanika. This is also lake.
Bhitarkanika, Lordship, is not a lake, but it is adjacent to the sea, Lordship.
Mangrove forest.
Mangrove, Lordship.
Mangrove forest sanctuary, it's a sanctuary.
Bhitarkanika, mangrove forest, bracketed sanctuary. Full stop. Next. This suo motu PIL was registered in 2017 and various orders have been passed from time to time. So stop. In the light of the directions issued by this court, actions have been taken by the authorities for demolition of illegal structures and earthen gheris, GEGHERIES.
Lordship, within 100 meters of the HTL.
As also eviction of illegal brackish water shrimp / prawn farm / ponds and other fishery ponds from the periphery of Chilika Lake. Full stop. From the 81st order passed on 19/12/2023, it can be seen that pursuant to an earlier order dated 4/12/2023, a draft comprehensive policy on fishing in Chilika was prepared. Stop. A copy of the said draft Chilika policy has been brought on record. Stop. We have been informed that a new draft Chilika policy is under the process of finalization. Who is finalizing?
Whereas the revenue and disaster department will finalize the.
Government has taken several times since last 1 year, Lordship,
By-
framing this.
Still by the Revenue and Disaster Management Department, Government of Odisha. Stop. It further appears that during the hearing of the present proceeding, an issue was raised as regards the rights of such non-fishermen societies, so more than one,
More than one.
who survive. Societies or society? One than more than one.
Societies. So the
Who survive by fishing in the Chilka Lake. Stop. P next. Learned counsel. You are
as additional standing counsel.
Mr. So and so learned additional standing counsel representing the state of Odisha has submitted that because of the general and assembly elections in the state of Odisha, Odisha, finalization of the policy has got delayed. And in any case, it shall be done within 1 month.
Within one. Whereas end of July is
By the end of July.
end of July.
Stop. He has informed that 2 experts, namely Dr. D. Sampath,
V Sampath.
V.
V.
Sampath What is his qualification? What is his?
Was he's former advisor, Ministry of Earth Sciences, Government of India.
Former advisor, Ministry of Earth Sciences, Government of India, and Mr. Ritesh Kumar, former Director, Wetland International, have been included. Services of services of two experts are being taken to assist finalization of the draft policy.
Draft policy.
Stop. We are concerned over the slow pace with which the opposite parties have moved towards finalization of long pending so and so policy. Stop. We shall consider on the next date presence of the two experts, forced two experts online for an effective assistance to this court to reach a logical conclusion stop. Logical conclusion, as also for the logical conclusion and for the purpose of issuance of appropriate directions. In this regard, appropriate direction for strict implementation of the provisions under the Coastal Aquaculture Authority Act 2005, the Coastal Aquaculture Authority Rules 2005, and the regulations framed thereunder. So stop. Nothing is beyond that.
Please be right.
There are three statutory provisions. So whatever action you take, whatever policy you make, all of them shall be within the provisions of these this thing.
Please be honest. Please be honest. Apart from that, there is a wetlands conservation rules, my lords. That is for wetlands, my lords.
Where is that?
That is also, my lords, I don't have a copy, my lords, but
those rules have been framed under which provision?
Please, my lords. These rules have been framed under section 25 read with subsection 1 and clause 5 of subsection 2 and subsection 3, section 3 and 23 of the Environment Protection Act. And these are specifically for wetlands conservation. And
when was
these rules came into being in 2017. Wetlands Conservation and Management Rules 2017.
Then it has come up 19, it has been.
No, that is, thereafter,
19
the
also that has
coastal zone regulations, they had come in 1991 and the latest one is in 2019. What those regulations say is that within the high tide line and the land, what activities can be done and what are restricted. And specifically for wetlands, there is this other regulation as well, which is the Wetlands Regulation, Management and Conservation Regulations 2017. So that regulations will also be taken into account by the experts.
No, but just now we were of the view that the Environment Protection Act, they don't have any provisions under that act.
No,
have no application.
That is for for aquaculture, but for environmental protection of the wetlands,
Now, the
Well,
court shall also consider the applicability of which rules?
Wetlands Conservation and Management Rules 2017.
Framed
under Section 25 read with subsection Section 1 and Clause 5 of Subsection 2 and Subsection 3 of Section 3 of the Environment Protection Act.
Again,
Please, Section 25 read with subsection 1.
Give that on a slip.
Lordship, subject to Lordship's permission. In fact, all these rules Lordship governs, regulates any activities just beyond Chilika Lordship. But here is an issue, Lordship. This issue governs inside Chilika. Because Lordship, there are fishermen, non-fishermen communities here.
We can widen the scope of.
No, Lordship. That is within the scope, Lordship, within this ambit.
We can widen. You cannot, but we can widen the scope.
No, Lordship, in my humble subject of Lordship, these issues have already been decided by this Honorable Court, by the division bench since 1994. And Lordship, it has been also confirmed, Lordship, in the 1997 by Honorable Supreme Court in case of S. Jagannath versus Union of India. In both the cases, Lordship have decided how to frame Chilika policy inside Chilika and how to accommodate both fishermen and non-fishermen. And considering both the judgments.
So have we passed any order contrary to the orders passed?
No,
by the Supreme Court?
No, Lordship. Here, Lordship, but all these rules, Lordship, only regulates the just bank of Chilika. But here, Lordship, enter the policies concerned, state policies concerned, they are framing policy how to regulate fishing inside Chilika. That is the difference, Lordship. These rules, Lordship, gives Lordship sufficient power to the authorities to protect Chilika just beyond Chilika, not inside Chilika. But they are coming with a policy to allow to accommodate both fisher and non-fishermen to fish inside Chilika. That is the whole difference, Lordship. That's why, Lordship, these two judgments, beyond these rules, Lordship, these two judgments also gives them hand. And this Honorable Court has given the entire guideline. What is the ratio and how the fishermen will be accommodated.
Which order?
Lordship, that is
in some other order, not in this proceeding.
Lordship, that has been taken care in this proceeding also, Lordship, by Lordship.
Order number 80. Order number 80.
80.
That has been.
Yes, it is there before. Yes.
Order number 80.
Yes.
Dated 4/12/2023.
So this is what we have noted in our order.
Yes.
Just now.
Yes.
Just now we have mentioned that non-fishermen, what is?
And fishermen. No.
All right, fishermen and non-fishermen also. Fishermen, they are doing.
Lordship, the fishermen having hundreds acres of illegal or unauthorized possession of pond. The fishermen, those who are fishing inside Chilika, Lordship, at different place of Chilika across Khordha district, Ganjam district, and Kuru district.
We will hear you.
Lordship.
Only on these issues, but not on the when you question an order in an intervention application, we will not take up that. But if you say that some illegality is being done, we will look into that. It's public interest. Are we clear? We are adjourning this for 2 weeks. After 2 weeks, the matter will again come.
Please,
next. Some intervention applications have been filed by the persons who are aggrieved by the actions taken subsequent to passing of the orders in the present proceeding. Full stop. One of such application is IA number 13647 of 2021. Full stop. In the said intervention application, this notice you have challenged.
Lordship.
You have challenged this notice.
Lordship.
The in the said intervention application, the petitioner has challenged a general notice issued by the district fisheries officer for the which reads as under quote karna pura annexure 3 from here to
Lordship, the general notice has been issued, that is, I have annexed, Lordship, in the said IA at annexure 2, Lordship, by the collector and district magistrate Khordha, Lordship. That I have annexed in this IA.
That you have given us also.
Lordship, that is the district fisheries officer instruction to the Tahsildar Chilika that before doing any kind of demolition to the pond, Lordship, those who are within high tide line or outside high tide line, do the measurement. That is the district fisheries officer letter, Lordship. But the annexure what I have done, that is the order of the collector and the district magistrate Khordha, Lordship. That is on 27th August 21, Lordship. That I have annexed in the that notification, Lordship, the general notice is that without giving any kind of intimation to me, without doing any measurement, nothing of any sorts, just high-handedly they rush to the spot and they demolish my recorded land. My concern, Lordship, what my problem is that, Lordship, nearer to Chilika land, Lordship.
Here you see how this notice applies to how many people?
Lordship, I do not know because I am.
You do not know because you cannot count.
Lordship, many people are there.
Therefore, we are saying that
Lordship,
if all the persons come to challenge this notice, unless they are individually
come in separate treat, Lordship.
The notice, the said notice, where is that? Let us see. Where is your IA? Where is your IA?
Lordship, that is at page 16, flag 97, Lordship, at the present. Flag 97.
One.
Which page?
Flag 308.
208.
Zero eight tells objection to IA. That is 6764 page. Flag 97.
There is another way also that we can dispose of this petition and file, start afresh, because it's impossible. So it has become, there are 10,000 pages.
Yes.
Please do it.
Lordship, I am a farmer. I was doing paddy cultivation because the paddy has been eaten away by the.
Mr. Counsel, please be kind to us. We have not been able to see your petition. Our digital copies, physical copies, we have not been able to see.
The connected read petition also can be Lordship segregated, and it can be decided separately.
Let us see.
Lordship, all are
Let us
different
see this.
issues, only because
All these connected read petitions are almost single bench. matter.
single bench matter, it can be
Those can be
all our
detached.
matters.
These are all connected. Tagged with
Because of
this-
Chilika matter and policy matter, it has been
all are,
classed.
even criminal revisions are tagged, which is to be heard by an honorable single judge.
All right, after 2 weeks, we will do some
Let's-
exercise. In the meanwhile, I'll ask the registry. Yes, Mila.
We have 96 and 97. The copy.
Those connected matters, tagged matters can be delisted and can be listed before the respective assignments.
96,
97 is his intervention.
Can you give your IA? Give
this copy is there.
Which order you are challenging? Which order?
The general notice of the collector, that is at Annexure 2, Lordship. Copy is not.
Annexure 2.
Lordship, that is the notice of the collector, Lordship. Without giving any notice to me, no individual notice has been served, and
Just a minute.
they rose to my fund and they demolished.
In the through by filing said intervention application, the intervener petitioner also seeks to challenge a general notice issued by the Office of Collector and District Magistrate, Khordha. It is the case of how many petitioners are there?
Lordship, my individual, I am the sole petitioner, Lordship. I have my 2 acres of land, I am the sole petitioner in this.
Sole petitioner.
Lordship.
But signatures are so many.
Lordship, so all around 60 acres of land are there. All the people, they make a representation to the collector that without doing any kind of demolition, give us chance.
Yeah.
And you do the measurement as per the letter of the district fisheries officer, that without doing any measurement, you cannot proceed. That is why
The intervener petitioner, it is the grievance of the intervener petitioner that pursuant to the said general notice issued by the office of the district collector and the district fisheries officer Khordha, you have been removed.
Lordship.
What has been done?
Lordship, what they have done, they have not given any chance to me to, they have demolished my, they have altered my land, Lordship by using.
We have filed our objection to this intervention application, and we have clearly stated that no demolition has
Lordship, the
taken place.
copy of the objection that is not there with me.
That certain land has been demolished, to which has been denied in the objection filed on behalf of the estate. Full stop. The grievance of the intervener application relates to the grievance of an individual arising out of action taken pursuant to the general notices issued by the district collector and fisheries officer cannot be subject matter of the present proceeding in the nature of public interest litigation. Stop. It goes without saying that if the petitioner has any intervener petitioner, namely, what is your name? Name of the petitioner?
Dushasan Patra, Lordship.
Patra has any grievance against any action taken by the officials, he shall have liberty to approach appropriate authority / forum in accordance with law. Stop. IA number so and so stands dismissed. Stop. Next, we make it clear that no interlocutory application in the nature of interlocutory application assailing an action in accordance with the provisions of under the provisions of so and so act or rules shall be entertained in the present proceeding. Aquaculture. In the present proceeding, which is in the nature of public interest litigation. Stop. In the present litigation, no individual grievance shall be entertained. How many interlocutory applications are there? All the interlocutory applications.
Several.
The registry
More than one.
is directed to find out as to how many proceedings have been tagged with the main suo motu writ application in the nature of public interest litigation, raising public interest litigation in which individual grievances have been raised for this court to pass appropriate orders on the next day.
Including the writ petitions which are tagged.
Yes. Therefore, we have said that
single
all
match
cases, all cases.
Yes.
Lordship, other writ applications which been tagged, it can be delisted with observation.
This is what we have directed the registry to do this exercise.
But Lordship, one problem is there, Lordship, because of pendants of the public interest litigation, Honorable Single and other division coordinated benches are not taking up the matter. Because in the name of.
What are we here for? We can clarify
Lordship.
while delinking the matter. It is not that
Lordship,
we shall make such observations.
observation.
So that is
Lordship,
not
grateful,
true.
Lordship.
Why do you have so much?
No, Lordship, no. Because duty.
I will not say that, but yes. Yes. That's just 2 weeks. 2 weeks. Please,
Lordship, on 20.
So the first exercise of the court will be to remove all the unnecessary things from the present proceeding. Then only we can confine to the main issue. Otherwise, for me, it is impossible to comprehend.
Then it will come on 20th, Lordship, after vacation. If
No, it will come after 2 weeks.
Then
Before.
20th, Lordship.
Before.
20th. At
20th.
At 2 p.m. Lordship.
Item 73.
My Lord, in this case, as directed by your Lordship, I have produced the original case record of that arbitration case. The entire case record also.
Conciliation.
Mind boggling.
Digital.
Digital na, original record.
Yes.
That part is there,
My lords,
that part is there.
the entire record he has sent. I have not.
Yeah, not.
No, I have not.
That MSc matter, my lords called for that record to see whether there is conciliation proceeding concluded or not. And when that conciliation proceeding have been. Conciliation proceeding has been done as per your statement. Whether the arbitration proceeding has started or not.
Conciliation proceeding.
Yes, you're right. You're right.
Right.
So you can see
I have
the
not seen,
records.
we have not verified the record.
Oh, you can see all of you can see the reports. These are not confidential documents. Please sit, Mr. Bishop.
Lords, may record that I have submitted because it will be kept as a part of this.
These are not confidential.
No, not confident, but I have submitted it before the court. That may be a part of the order.
All right. Pursuant to this court's order dated. What is it called?
One 27 page.
Dated 1/5/2024. The original records of MSEFC case number 51 of 2019 has been produced by Mr. Devkant Mohanty, additional government advocate. Yes, for the court's approval. Please sit down, Mr. Mishra. Please sit and sit.
There also the all that are filed refers to conciliation. Filing of the conciliation petitions thereafter. The order, total order sheet we have not yet found.
Order sheet is not there. The orders, dates were mentioned in the issued order. That orders are not there.
A record of proceeding is not maintained. Record of proceeding that
It
they
is
don't
not
maintain.
available in the file.
Last order.
Orders. No. এইগুলো অর্ডার দিতে ছিল
Our background and inclusion challenge.
সেটা আছে হ্যাঁ ডেট
তারপরে আমি ফাইল করছি
Not in while passing a particular order.
Final order date is there.
Final order, final copy of the final order is there, whatever I enclose minors in
That is the
the
impute order.
petition, including order in the writ petition. Accepting that, when after the order passed by the Honorable High Court, the file dealt with, we have filed objection, written statement, and all these things are dealt with. Because arbitration proceeding commences, that is the order, and thereafter started. Nowhere there is order that yes, the conciliation proceeding concluded and arbitration proceeding commenced, and thereafter the order passed. There is no such document.
The issued order refers to 5-7 orders. I couldn't get.
But everything, it appears to be, everything was perfunctory. Right,
Yes,
set aside.
parties must have appeared for him.
Parties appeared not
And
for
yes,
conciliation, that is one aspect.
No, but in any case, sealing does not inspire confidence.
For the
Official
office note today. Note sheet.
Jimmy orders.
Mm. 84 sitting where there must be 84 sitting is different cases also, including different cases. That note sheet, order sheet must be there.
But if nothing is there, then what can we do?
That they have jumped to another proceeding without
But I couldn't get the
Formulating-
record. The records
There is
are
a
not-
note sheet, there is a note sheet.
uh,
One after the other, the dates are mentioned and some notings are there.
proceedings.
That is enough.
Like judicial records.
That is
No, even administrative records in taxation matters, they maintain each day record of proceedings.
That is
And
there.
even
In
they are quasi judicial
taxing,
activities, they
no, director of industries, yes, this is also,
quasi judicial,
yes,
this is quasi judicial function.
Quasi-judicial.
They are bound to.
Should I ask the director whether any other order sheet separately is available?
You can get tomorrow. You can get one tomorrow,
Day after,
order sheet.
day after tomorrow.
All right, as requested. So,
No, I will ask whether it is available or not.
all right.
Any other
On perusal of the
papers
original
pertaining to
notes, we
this?
notice that it does not contain any order sheet,
Day-to-day orders.
day-to-day order sheet. Note sheet is there. Note sheet is
Note
there.
sheet is there.
Note sheet is there. Every note is there. Order sheet. Stop. List this matter on day after tomorrow.
At 2 p.m.
Wednesday. To be taken at Takaba at 2 p.m. For Mr. AGA to inform as to whether there is practice of maintaining any order sheet in such matters or not.
Or if any such order sheet is available, I will produce it.
Such order sheet was maintained, let the same be produced before this court. Yes.
Item number 26.
My lords, item number 26, my lords, on last occasion, Mr. Manti had communicated regarding his unavailability due to some personal inconvenience on Monday. My lords.
When do you want?
My lords, 1 week after.
1 week after? All right. Huh? All right, 1 week as requested.
Obliged, my lord.
Item 27.
27, my lords, permitted to drop, my lords. We got a notification.
Order has been complied with.
It is jointly submitted on behalf of the parties that this court's order violation of which has been alleged in the present contempt application has been complied with. Stop. The contempt proceeding stands stopped accordingly.
Item 28.
But both 28 and 29 also complied with, and I have given copies to my friend also. I don't know where you are.
There is no representation on behalf of the petitioner. So stop. It is stated by legal counsel and AGA that this court's order violation of which has been alleged in the present contempt application has been complied with. So stop. A copy of order.
Yes, the order passed.
Copy of the order passed in compliance of this court's order has been served upon learned counsel for the petitioner. He submits full stop. This contempt application stands dropped in view of the said submission.
Item number 30.
29 of
30, I would pray your lordship some more time may be granted to.
My lord, this is order dated 22/2023. Already 1 year has elapsed.
all right, 1 week more. 2 weeks.
Yes,
last day.
Yes,
last day we will take up contempt matters.
Yes, ma'am.
Friday.
There is a special list for Thursday. Some
Special
matters
list for Thursday.
Yes, some matters are there. Not
all right. So this matter will come on Friday.
This Thursday
will not this Friday.
Next Thursday.
17th.
17th.
Yes, ma'am.
It should be the last chance, my lord.
List this matter on. Huh?
It should be the last chance.
Last. Okay. Don't worry. We are more concerned about implementation of the orders than you.
Item 31.
Obliged.
Item 31, let's say, I may be permitted to appeal through visual, let's say.
But 31 also,
Also, I pray also the superintendent has written to the aspiring executive engineer. Some more time is required because it's a financial transaction. He will some 2 weeks time will also be required.
2 weeks.
Yes.
All right, last
17th.
17th.
Yes, sir.
Item 32.
My preacher laws. The background of the case is, it is a land acquisition proceeding.
This matter on so as requested by Mr. AGS also to report full compliance of this court's order, violation of which has been alleged in the present contempt application.
My preacher, item 32. The land acquisition proceeding. For 99 years, in the year 1999, I had purchased this property. It was mutated
No,
in
let
my
us see the order.
But the order is, there are 2 orders. In fact, one substantive order, which was not complete. Since it was not complete, I approached again. This order was passed at page 9. Page 9, you'll also kindly see, direction was to dispose of my representation both 10 and 11, keeping in mind annexure 14. 10th and 11th, with regard to implementation of my earlier petition. And since there is no award in my favor, I came up with a plea that it should be calculated in view of as per the new act.
No, you are alleging violation of which order?
This order at page 9, 13, passed in WPC 3798.
What is the order?
Pardon me?
What is the order?
Order direction was to dispose of my representation, where I had alleged that my award should be calculated as per the new act. Keeping in mind,
Please come to paragraph 5 of the order.
Paragraph 4, rather, my lord.
Paragraph 4 is nothing. Paragraph 4 is
the course
just
of hearing.
prayer.
In course of hearing, I'm placing them. In course of hearing and counsel.
Paragraph 4 we will not see because paragraph 4 is not the direction. Paragraph 5 is the direction. Come to paragraph 5.
Dispose of the petition directing the opposite party number 3 to consider the representation filed by the petitioner, filed annexure 10 and 11, taking into consideration annexure 14 and pass appropriate order in accordance with law within a period of 3 months.
Whether this has been done or not?
No.
Yes.
It is
When
not.
will you do?
It's not done.
We have disposed the representation. We have stated that there is a dispute in respect of 2 plots.
All right. Where is that order?
We have disposed of the
Then where is the
order has been communicated to him.
Well, also kindly see, but kindly have a glance. There are 2 orders. One substantive order, which was passed in the division bench of this court in
Mr. We are in contempt jurisdiction.
313. Well, that annexure 11 will clarify, my lord. Annexure 11 is to be.
We will not see anything for the purpose of contempt proceeding. We will see only operative portion.
I bowed on, my lord. Annexure 11 kindly have a glance. That
We will not. We will not. We are considering violation of an order. We cannot go beyond what is
They have
there
not
in
paid
order.
anything. There is no award. How it will be referred under section 30 merely because saying that they have disposed of my representative.
That question you should not put.
I am not putting, my lord.
You are putting that question to us.
My lord, kindly have a glance. 81 years old person is running from pillar to post to get his award, my lord. And his residential house has been taken over
Petitioner
despite of
has
the impeachment.
filed the present contempt application alleging disobedience of this court's order dated 1/3/2023, passed in WPC number 3798 of 2015. Stop. Operative portion of the said order reads as under paragraph 5. Stop. Next, it is not in dispute that the petitioner's representation has been disposed of by the opposite parties. The and counsel for the petitioner has submitted, however, that the petitioner's representation has been wrongly rejected without taking into account what?
My WPC number, my order passed in
Without
31319.
taking into account an order dated
Order dated, my lord, order dated.
23. I'm not sure exactly.
Order dated 25/9/2012.
25/9/2012. Passed in?
Passed in 31319 of 2011.
319 of 2000.
WPC. WPC 31319 of 2011.
2011. Full stop. The court, while disposing of the petitioner's the writ petition, by order dated 1/3/2023 has specifically declined to express any opinion on the merit of the case and had simply directed the opposite party number 3 to consider the petitioner's representation and dispose of the same. First off, the representations having been disposed of, in the court's opinion, no disobedience of this court's order is made out. First off, the submission that made on behalf of the petitioner that an order earlier passed by this court has not been considered by opposite party number 3 while disposing of the representation cannot is not sustainable for this court to entertain the present contempt application. First off, the contempt proceeding stands stopped accordingly. Yes.
Item 33.
Connected mirrors. Here also we have considered and departed.
Without award 30 minutes, without giving an opportunity even.
It depends on everything depends on the nature of the order which you get. Opposite party number 4. Yes.
Item 34.
So 34, this is covered by a lawsuit order. Because we have not the Bindusagar's case law. There was a direction for compliance of the order in a writ petition.
You are in Supreme Court, so.
So Bindusagar, you also have very recently passed the same order. Here also same Bindusagar mirrors. Sorry.
Yes, we are disposing it of.
How to get a case for love? Don't even ask for no even. To also dispose of same loss.
The petitioner in the present writ application, present contempt petition has alleged disobedience of which order?
Yes, disobedience of a lawsuit is the order dated, but passed the writ appeal number 1800/2002. Yes, that is at page 9. Order dated 25/9/2023. Page 9 of the brief. Order says, in view of the common order passed today in writ appeal number 810/2020, that is State of Odisha versus Bindusagar.
No, this order.
1800/2022.
And date of the order?
Date of the order is 25/9/2023.
WA number change.
Can you make the necessary correction?
Correction, I can do it. I can.
I beg apology, my lord. I beg apology. I was election court number 15, my lord. Item 28-29. I beg apology, your lordship.
Solid, no problem.
Not complied, your lordship. Item 28 and 29.
No,
I've given copies to my friend.
Yes, your lordship. Because the authority has no power to reject. This honorable court, your lordship, directed to the director to pay the compensation. But the special land action officer,
Let
who
us
is
see,
not
let us-
authority
Don't
to-
worry, don't be get excited.
Yes.
We are here to protect your. What is the order?
Yes, your lordship.
Let us see the order.
Yes. Running page 10, your lordship. Running page 9 and operating person of 10, your lordship.
Considering the above, this court dispose of the writ petition with a direction to the director RR and additional secretary to government Department of Water Resources opposite part number 2 to sanction the proposal submitted by the collector Nuapada opposite part number 3 by the letter dated.
So whether it has been sanctioned or not?
Not it, but the special law rejected the case on the ground that the petitioner is not eligible to get the compensation.
Yes, Mr.
Yes, Lordship, kindly look at a given mirrors. Because here it was found, I will give the reasons. Here it was found that he is not eligible because
No, there is no reason. There is no reason. The court says that considering the above, this court disposes with a direction to so and so to sanction the proposal.
Exactly. Here what had happened, the LO had submitted a proposal to the government for sanction. At that stage, they came before the Honorable Court saying that it is pending with the government, so it should be sanctioned. Order was passed. Then it was when verified by the government, it was found that sufficient document showing the date of birth, age was not given. So accordingly, the government remitted the matter back to the LO to give the details of the date of birth.
That option you did not have. You would have filed a review. Because here is a positive direction to sanction. Because
there was no.
If there was some illegality, something wrong, you could have sought review.
Then Lordship, kindly give me some time because it was found that fraud has been played, saying that the date of birth has been given a fraudulent document.
So that is good ground for review.
Yes, not that because the government remitted back saying that.
28, 29,
No, this is one. The other one was.
Another one, Your Lordship, 29. This is the second contempt.
Just a minute. 28 को कर देना after it is for learning counsel and AGA to seek further instructions as regards compliance of this court's order, violation of which has been alleged in the present contempt application. Yes.
Item 29.
Just a minute. Yes.
Your Lordship, kindly see the order passed in the contempt application on page 15.
Just a minute.
First, Your Lordship, kindly come
Yes,
to
read
original
that,
order,
yes.
page 11.
Page
Original
11.
order, page 11.
Yes.
Paragraph 1, 2, 3, 4, 5. This being the limited grievance of the petitioner, we dispose of the writ petition with a direction to the opposite party number 2 to take a decision on the proposal submitted by the OP number 3 under Annex 2 within a period of 8 weeks if there is no other legal impediment and communicate the decision to the OP number 3.
Thereafter, Your Lordship, the order passed in contempt application.
Contempt application cannot widen the order already passed.
Here, Your Lordship, similar matter, the proposal submitted by the collector for sanction. That the contempt application, the government has taken the view, Your Lordship, kindly see the running page 15, Your Lordship, the order passed in contempt application. The stand taken by the government. Paragraph 2, running page 15, may I read, Your Lordship?
What can be done? Second order is there.
No, second order is that failed verification is going on, Milos. If your Lordship kindly come to paragraph 2 of that order, page 15. AK Mr. Additional Government Advocate placed on record letter to such and such Additional Secretary Government of Orissa, wherein it is stated that the process of field verification to ascertain the genuineness of the claim of the petition is being examined.
Nothing, Mr. Counsel.
So it doesn't mean that
there is no positive direction for payment. Everything was to depend on the verification.
Paragraph 4, Your Lordship.
Yes, we
There
have
is a positive direction, Your Lordship.
We have read. Please read it. There are two aspects. One, the order passed in the writ jurisdiction could not have been widened in contempt jurisdiction. And two, there is no such order. There was an order to sanction. Here we don't find. It all depended, it was complete the verification that they have done.
Your Lordship, this order has been passed the contempt order has been passed
You are now
on
completed.
28
You are now
June 2023. You Lord
You have
kindly
now
see.
completed.
Yeah.
You have now completed.
No, yes, ma'am.
Complied with.
29 we say we have completed. 28 so I will take time, so I will file a detailed affidavit.
29 we have complied.
Yes.
It goes without saying. 29 it goes without saying that the petitioner shall be at liberty to question the correctness of the decision taken by the contemners
May I submit one thing, Lord?
while complying with this court's orders dated 14/9/2020, passed in WPC number 2057 of 2020 and 28/2023, passed in CONTC number 5116 of 2020. Yes, 29 disposal.
Liberty may
Item 34.
challenge the same, Lords.
Item 34.
No, 34, I've stated that Bindu Sagar, no, so I've corrected. The date of disposal of the writ appeal is 25/9, same Lords, and case number is 1800, Lords.
This is item number?
34, Lords.
Yes.
35.
35 also, Lords, same Bindu Sagar, Lords.
Writ appeal?
Writ appeal only, writ appeal number is 544 of 23. Date of disposal, same, Lords.
544.
Item 36.
36, there are two items, Lords. Lord, the officer concerned is busy, Your Lordship. I will seek some time, Lord. 17th, Your Lordship, call it, Lords.
17.
Item 37.
Both case 17. 36 with matter.
Item 37.
So 37 we have partly complied with because there was a direction to give all the benefits. It has already been sent to the concerned authorities. Lords. I've got the instruction from the authority that it has been submitted to the GPF and other things have been paid. So far as final pension is concerned, it has been submitted. It will take some time. So Lords may call it 2 weeks after. In the meantime, we will get the entire details.
After
partly complied with.
Item 38. Item number 38.
No, 38, this is the order has been complied with. The learned district judge Bhadra. He has paid pursuant to lordship direction, everything has been paid. I've got the compliance affidavit ready. If your lordship can direct me, these are the orders he has already done, Lords. He has sent me through mail, Lords. Everything has been paid to him, Lords. Amount has already been paid.
There is no representation on behalf of the petitioner. So we have been informed that this court's order dated 29/11/2023 has been complied with. And the petitioner's leave salary and
gratuity,
leave salary, gratuity and final pension has been authorized.
Yes, has been paid to him, Lords. Commuted value of pension,
paid.
everything has been paid to him.
So the contempt proceeding stands dropped accordingly.
Item 39.
39, my lord, I may be permitted to VC your lordships. There is a specific direction, last order of your lordship, 6th April 2024.
I'm sorry if my friend has not been served with the copy of the compliance affidavit. I filed it on 3rd of May, Lords. So if my friend has not got it, he can collect it from me, Lords. Because we have gone to the Honorable Supreme Court, I've given a, so I can give to my friend, Lord, the copy of the affidavit filed.
They have filed. SLP.
Like today was let me some other day so that what they have, I have no, your lordship not is with no, the compliance affidavit not is with my hands, your lordship. So
Compliant, no. See, they have files appeal. You have gone to Supreme Court?
Yes, my lords.
There is any stay or my lord, I have no the idea whether there is a stay granted only that if it sometimes.
The state lists this matter on after holidays.
Obliged.
Item 40.
Well, direction maybe copy maybe short my lord senior with your lots of my specific
Yes,
direct
I
copy.
filed the compliance affidavit already.
We have not got any copy.
Give
Not
him.
so.
I'm giving to my friend, Lord, just now, Lord, lost my quality any day. I've given it. I filed it on, Lord's 22nd.
No, but if the order has been complied with, then why should it remain pending? See, give him a copy.
I'm giving him a copy, Lord.
What is the compliance?
Because paragraph 5 of my affidavit, I've stated that, as per the direction of the Honorable Court, the petitioner has submitted representation on 4/5/2023, and the OP forwarded the representation to special LAO, Sukinda had memo number such and such, and which are received by him, and he has to send the proposal to the government for approval, and after approval, he will place the dependent for placement of funds after, and we have stated that process will take some time. This is the affidavit I filed, Lords. If you Lordship kindly give some time also, Lords, I can give details whether it has been done or not. If Lordship can call it after the holidays. Because now they've complied, there was a direction to Lords comply the order, but they've done it in pen and paper, but actually he has not got anything. After the holidays.
Does this matter on after holidays? As requested by Parent DGA to inform this court regarding full compliance of this court's order, violation of which has been alleged in the present contempt application. Yes.
Item 41.
The series of cases, there we have complied the order. In all the cases, I'm giving the copy of the order because there was a direction. People also kindly come to the direction.
The land was acquired for the purpose of a Tata power project. And
Minister, your representation, whether it has been disposed of or not.
I have not received anything.
This is what he's
I'm
giving.
giving him all these copies one by one, all 6 cases. I'm giving you the orders in your path.
Oh, your orders have been passed. That was the direction.
Please, you note, sir.
And you can challenge. The orders were passed on the same day.
Orders have been passed of 4th May 2024. Pursuant to losses.
It has been stated by learned AGA that pursuant to this court's order dated 2/3/2023, passed in WPC number 4376 of 2023, the petitioner's representation has been disposed of, and thus this said order has been complied with. A copy of the said order has been served upon learned counsel for the petitioner. The contempt proceeding stands stopped accordingly, since this court's order has apparently been complied with. Since this court's order for disposal of the representation has apparently been complied with. So it goes without saying that if the petitioner feels aggrieved by the orders passed on his representation, he shall be at liberty to question the correctness of the same before appropriate forum/authority in accordance with law. There are 6 petitions, 6.
Yes, yes. 7 cases. 1, 2, 3.
What about 7?
Six, sorry,
Six
six,
cases.
sorry, six.
So next is Bindusagar. Only writ appeal number is 1354 of 2020-22.
42.
Yes.
42.
Item 42.
42. So they have filed appeal before Supreme Court.
Well,
So no contempt. Yes.
43.
Item 43 plus 43 lordships, his proposal for financial benefits has been placed to the finance department. 2 weeks time has been sought for by the authorities who will comply the order.
Put upon 17th.
Yes, 17.
Yes.
No, positively.
46 item,
44.
that matter we have filed a review. 46, we have filed a review because it not being possible to comply the order. And that review, my lord, the order was.
Just 1 minute. Yes, 45.
44.
44 taken up 17 months, 17th.
44 is on 17th.
Madam,
44 I filed the complaints affidavit.
I have filed objection, madam, that not
Yes.
complied, madam.
Let us see, let us. Okay. 44.
Madam, 44, just 2 days back, I have received.
Let me see the order first. Let us see order.
Taken up next week.
Mr. Whether your representation has been disposed of or not.
Madam, that have not complied fully, madam. That
Come to the order.
Page 10 minutes.
There is nothing. It is an admitted position that the petitioner's representation has been disposed of by opposite party numbers 4 by the contender in compliance of this court's order dated 16/3/2023 by an order, a copy of which has been served upon learned counsel for the petitioner. Stop. Next, learned counsel for the petitioner is not satisfied with the order which has been passed on the petitioner's representation. Stop. In our considered opinion, no deliberate disobedience of this court's order is allowed. Most of the contempt proceeding is accordingly dropped. Most of the petitioner shall have liberty to question the correctness of the order passed on his representation, in accordance before appropriate forum in accordance with law. Yes.
Item 45.
45 not yet complied, madam. No stock was
45 months we have complied the order. By order dated 1/4/2024, representation has been disposed of by the collector for the.
no copies have.
I'm giving
Receive it. Unnecessary this matter. Same order.
Item 46.
That item 46 I am in virtual mode.
Lordship,
That
kindly see
the
the contact order.
operative portion of the order, your lordship can.
Let us. You are in 46.
Yes.
Yes.
Lordship, kindly see the order.
So you are appearing for whom?
I am for the alleged contender and also the review petitioner.
So you cannot do same. See, if you are
appearing in the contempt.
No, he is for the contempt.
My learned senior is appearing
Contempt
in the-
petitioner. He is with me, and in the review we have filed for review of the order because it is not being possible. It is just like a PIL matter. That means to construct a road. In the road in between, that is burial ground is coming. Burial ground, once upon a time on the allegation of the people that some land grabbers are making development of the land, it is side of the national highway. So that is why they have some intention that how to make a road.
yes, who you are appearing for whom, Mr. Sahu?
That I am appearing for the petitioner.
So a review application has been filed.
That the review application which has been filed, my lord, only to frustrate the order of the direction of your lordship, my lord. Lord,
Maybe that can happen.
everything was in the writ petition. This ground was taken in the writ petition. We have specifically played that these are the plots over which the road will be constructed. That did not object to that. Your lordship can see the operative portion of the order. Can it be possible by filing a review petition now? They will frustrate the order of this honorable court, my lord.
They cannot frustrate the order. They have filed the review application that can be seen by the revision bench.
Review application has not been served upon me.
That is not a contempt.
The delay is there, that is why file the petition for continuation of delay.
No, but give him a copy.
Yeah, we have Lordship direct will give a copy.
London counsel appearing on behalf of the contender has submitted. This is a violation of which order?
That order
That
dated
violation of the order dated
2/11/23.
2/11/23, and they have given the consent before this honorable court that will construct a road within 3 months. All the plots are there, and the plots over which the road is to be constructed. That is also
Mr. Sahu, it is settled position that something which is impossible to be done cannot be directed to be done. So if
Yes,
they are
ma'am.
taking this plea that it is impossible for them to construct the road, no question of contempt is made out.
that I will satisfy your lordship, it is possible.
Where is the question? All right,
It
let
is
him.
possible because it is a big plot and
See.
only two
Lordship
districts
direct
of
can
land
give
the
the
road
copy
is
to
to be
him.
constructed.
All right.
Lordship keep this matter
And
up.
they have also passed the resolution that the road is to be constructed.
All right.
No.
See, we cannot pass. Review is because of other.
Yeah, but
That is why Lordship direct appropriate bench.
Before.
that is he's saying that the direction to serve a copy.
That is not before us.
All right.
It is stated by London counsel appearing on behalf of the contenders that a review application has been filed seeking review of the order, violation of which has been alleged in the present contempt proceeding. So stop. London counsel appearing on behalf of the petitioner has, however, submitted that the said review application has been filed just to frustrate the purpose of this court's order violation, which has been violated by the contenders. Drop text. Be that as it may, considering the circumstance that a review application has been filed, we are not inclined to presently proceed with the present contempt application. Stop. List this matter on 6 weeks, 2 weeks after holidays.
Obliged.
Let them be directed to serve the copy of the.
I'll give.
That is not within our.
I'll give the copy.
Item 47.
Ma'am, please, Your Lordship. Your Lordship, in the connected writ petition, it was directed to the present opposite
Now
party.
we have crossed the court's time. Can we? Should we rise?
It is a small matter.
Small matter. What happened?
The order was comply indexing. The order was in indexing, the matter of indexing, my lord. And
land.
It was
Please try it. Yes.
4 weeks was granted to act upon the order, but it has not been complied
Yes. Very serious matter. Why?
with. It is already been 10 months, my lord.
Sir,
Your Lordship.
which item is this?
47.
How much time?
It already been 10 months.
We are giving you more time. 8 weeks time is allowed for the contenders to file an affidavit stating as to whether this court's order has been fully complied with or not. Order, violation of which has been alleged in the present contempt application has been fully complied with or not. Yes, sir.
52 may be taken up next week, my lords. I have already talked.
All right.